What is this? Why not? Yes.
My lord, may I be permitted to mention this matter was supposed to be listed on the first day of circuit. A report had been called for, and this matter was related to national importance and defense preparedness, my lord. And this has not come in the list, my lord.
The national importance.
The project itself is it's the Sivok Rangport
Show me
Tunnel.
the last order. Show me the last order that it is supposed to appear in the first.
May I just come back?
Just come back tomorrow.
Malik, may I just come back in 2 minutes? I have the order.
If the mentioning continues, then otherwise tomorrow.
My lord, may I be permitted one matter under heading motion, my lord. My lord, the petitioner, present petitioner is a senior citizen and retired teacher, my lord. My lord, during his retirement, he has to pay the overdrawn amount, my lord, and the pensionary benefit he is getting now, my lord, it is lower than the scale. Supposed to be getting.
ফাইলটা আমার বাড়ি থেকে এসেছে যেটা সুপ্রিম কোর্টের জাজমেন্টের ওটা আনতে বলো
No, my lord, this is first time I am mentioning, my lord.
If the report is not filed, how can I take up in absence of report?
My lord, under heading motion, my lord.
That's right. The amount has been deducted.
My lord.
ক্যালেন্ডারটা আমার চোখের সামনে
And the pensionary benefit he is getting is also lower than his scale, my lord.
pensionary benefit that is without report cannot be decided.
My lord, an overdrawn amount is also he has been compelled to pay, my lord.
Are you called by? 8th September.
Grateful.
Affidavit of service and other side should be here, otherwise it will go out.
May I be permitted to mention?
Take the microphone.
It's supposed to appear yesterday, date has not appeared in the list.
Why supposed to?
The listing date given by us was
In the present
in the present difficulties. The petitioner's husband was murdered in broad daylight. The principal accused is still roaming free. I want impartial investigation. None of the arrests have been carried out till that. They are threatening.
New motion tomorrow. But where is the other side? And in this matter, you served the additional advocate general also. And who is there? Mr. Namankur Pal, who is there? How can that? How can I have to inquire from the
office? May I be permitted to mention two analogous matters?
To anybody? Additional advocate general, Mr. Pal, you also inform. He must be here. And you give a copy to Mr. Namankur Pal also.
May I be permitted to mention two matters, my lord?
Must be here. This type of matter. Right? It is a request of the court. Ask him. May convey the request. Mr. Pal, convey the request.
My lord, may I be permitted to mention two matters?
May I be permitted to mention one
matter,
my lord? What is the charges?
My lord, by this honorable court, my lord, when it was first taken up, my lord, records of right was detected based on forged deeds. As the honorable court had verified, report was submitted along with the particular deed.
So you are really challenging the entry of record, entry in the record of right.
Inaction, my lord, because subsequently, my lord,
Inaction.
My lord, kindly gives me My lord, after that, what happened? They have come up with a report, the respondents. Thereafter, my lord, court not being satisfied had constituted a committee directing the DM to constitute one 3 members committee and file a constituted report. Now, my lord, those reports, my lord, are showing that the block land reforms officer, they are the record of right, they have to maintain that. In that, my
So
lord,
you
out of 20,000.
effected the correction in the record of
My lord,
right.
that is not done, my lord. That is separate, my lord. Here, my lord,
Record of right has been
yes,
corrected.
my lord.
Then
But they are not able
ah,
to produce records. They have the fake documents were put in record, and my it was.
sir, you are satisfied with the recording in the
My
record
lord,
of right.
that is not the issue here, my lord. My lord, after the committee was constituted, it was to look into the affairs how they could have done it because the officers of the department were involved.
Proof they have done it.
Yes.
But you are not affected by the recording in the record of
That
right.
is separate, my lord. They have corrected that, but my lord, there is a
Correct
notification.
according to your demands.
Yes, as
So
per
you
my
are
application.
satisfied.
That is separate, my lord. That I have taken 54. But my lord, here there is a notification of the principal secretary. Wherever these kind of deeds are being used to correct the record of rights, there is a notification that the wrongdoers have to be punished. Now, my lord, the department itself is involved, my lord, because in the order sheets that are there, wherein the forged documents were placed, there are references of the staffs who have given recommendations. Now, the report says out of 20,000 records maintained by that office, 5,000 records are missing, and all the relevant with respect to these
So the
particular issues,
report
all
has
are
been.
missing. Yes, my lord. Now, final adjudication is
What
required.
final
My
adjudication
lord,
in what?
because there is a huge discrepancy, my lord. 5,000 records.
What final adjudication from
My
a
lord, the
court?
wrongdoers has to be brought to justice, my lord.
You initiate criminal
My lord,
proceedings.
that I cannot, my lord. That is at the behest of the state, my lord. My lord, that is not satisfied, my lord. That there is certain urgency, my lord.
Tomorrow.
Yes, my lord.
Tomorrow.
Yes, madam.
Oh, tomorrow.
My lord, may I be permitted to mention one matter, my lord? Am I audible?
They are not a party to the writ petition, my lord.
Made a application under page 56 for additional cancellation. Whatever.
Report filed.
Report, my committee report filed, my lord.
ঠিক
And
আছে
alarming, shocking facts are disclosing, my lord.
আসুন এটাকে দিয়ে দাও তো মোশন
My 2 matters are running as of now.
who is leading you
I am doing it myself.
Monday
May I seek your
motion
lordship?
Monday
My
motion
lord,
Monday
another matter, my lord. It is of
but
yes.
if I find a vexatious proceeding sir
No, my lord.
if I find I will hold if I hold it is vexatious with reasons then be prepared for the consequence.
Yes, my lord. Another matter, my lord. Life and livelihood of a person is concerned, my lord. He was an GST registered, my lord. Without following the due process of law, his GST registration has been cancelled. Now he,
Preferred have been preferred
my lord, or it is at risk, my lord. Risk. They have
appeal
filed
preferred
affidavits, my lord.
appeal
Yes, my
preferred
lord. That was also tribunal is not there, my lord. Adjudicating authority and appellate authority, it's done, my lord. Now, no,
now what is the order of the appellate authority
they have affirmed the adjudicating authority, my lord. But my violation is that it was GST started the inquiry and it was subsequently.
you read my judgment I delivered yesterday.
That is true. But here, my lord, investigation started by CGST authority and then final order
It's a
passed by
hearing matter
SGST.
hearing
It's a
matter
short matter, my lord.
maybe short
It is covered by the
maybe
Honorable
the
Supreme Court.
shortest yes
GST,
let
my
me
lord, his livelihood is concerned, my lord.
yes
He's not able to do any
I
business.
appreciate but let me carry out some work on the hearing matters. Yesterday the entire hearing list was called, not a single matter has been done, not a single matter has been done, so no inclusion. Chalo. Next.
May I seek your lordship's leave to, my lord, to mention a matter, my lord. My lord, in this matter, there was a direction upon the state respondents to file their affidavits in opposition. My lord, lastly, it was taken up by your lordship, my lord, on 24th
Sir, it's a hearing matter, I will not
my lord,
include.
the time was extended, peremptorily extended till
Yes,
January
yes,
31st, my
yes,
lord.
I can
My lord,
prove.
lastly, by your lordship, my lord. Kindly take up the order from all the
Next.
motion matter, lordship.
What is the urgency?
Urgency, lordship, record of right not corrected by the BLO.
Lord.
Maintainable. All right, give it. Maintainable.
Just consider my representation.
No,
What is this
it's
still?
not maintainable in 226. Give it. Tomorrow. আচ্ছা এটা লেখো মোশন, এটা নিউ মোশন টুমরো।
My lord, may I be permitted to
Here for
mention
the
one matter, my
petitioner.
lord?
Why you're mentioning? You carry take out an application for vacating. Next.
Sorry, inclusion, new motion matter. Was supposed to be listed on.
Your land. My God. Now see the reverse situation. Who is on the other side? Give notice, affidavit of service, come tomorrow. New motion. Acha, motion tomorrow.
New motion,
Motion tomorrow, but if affidavit is not directed, if I find in any matter affidavit in opposition has been directed, I will adjourn the same for 1 year.
Yes.
Then I will not take up. It's a hearing matter. No. Hearing matter I will not.
Lordship,
Let me do work on the pending hearing list then. And yesterday the entire hearing list has been called.
Lordship, may I permit to mention one matter under the heading motion, Lordship?
And I tell you repeatedly, if somebody says motion, I include. But if I find there is a direction for affidavit, minimum adjournment will be 1 year.
Lordship, this matter relates to illegal construction, Lordship. The
Motion tomorrow.
My lord, may I be permitted to mention one matter, my lord?
Okay.
inclusion in the new motion.
Why?
It was supposed to be listed on 2nd September, but it was not there.
New motion tomorrow.
My lord, may I be permitted to mention my
The order is fine.
Wait. Yes.
two matters, my lord?
Tomorrow, but give notice and affidavit of service. And if other side is not there, I will not take up.
Correction of order, madam.
এটা দরকার পড়লে তখন জমা দেব, তার আগে জমা দেব।
That is required to be corrected. Very small correction.
To be mentioned tomorrow. If these type of matters are taken into list, madam, how does it matter? How does it matter? How does it matter? If this type of matters are to be taken up, when should I take up the other matters? How does it matter? The name is there. Even then. Hey, এটাকে last day তে দাও, পৌঁছতে পারলে হবে।
My lord, may I be permitted?
শুক্রবার লাস্ট একদম 12th.
My lord, may I be permitted to
To be
mention
mentioned.
one matter, my lord?
12th.
It's a new motion matter, Lordship.
What is the urgency?
Lordship, it's a new motion matter, Lordship. Not move, Lordship. Supposed to appear.
New motion. কালকে দিয়ে দাও।
My lord, may I be permitted to mention two motions?
Give notice, affidavit of service and other side. And other side, if other side is not there, I will not take up.
Two matters, my lord. State was directed to file a report, my lord. No copy of report is served to us, my lord. Child of the petitioner is missing since long, my lord. That is why
Monday.
two matters.
My lord,
Motion. Same, two matters, child, two children.
Yes. Two separate cases, my lord.
এটা মোশনে দিয়ে দাও সোমবার।
My lord,
my lord,
অ্যাপ্লিকেশনটা দিয়ে দাও কালকে, অ্যাপ্লিকেশন কালকে। Hearing, affidavit complete. Mention afterwards, after this vacation. In the mention in January.
my lord,
For increasing the
Why?
hearing matter of six.
In January, you mentioned.
My lord, the order your lordship asked for.
Yes, show me.
My lord, I'm
I
appearing
apologize that I did
online.
not have
May I
it
be
before.
permitted to mention one matter,
I
my lord?
apologize that I did not have it before.
Amit Das.
Yes, affidavits directed.
No, my lord, that is just a CAN application. It is not a affidavit. It is for this intervener had filed a application which was
You
not
want
in
listed what?
but the motion.
Motion.
Under motion, my lord. This was because it is at motion state, my lord. Your lordship would see the order, my lord.
Achha, let the affidavit in opposition to the application.
Intervention application, my lord. Intervener had my lord intervened and he had filed which was not entertained, my lord. The project is going on and we are the people supplying the aggregates for the project. And within 5 years, the project was supposed to be completed.
So what do you want at the motion stage?
My lord, an
Have those reports come?
My lord,
Paragraph 9.
my lord, the report is supposed to come, my lord. We have also appeared before the monitoring committee also. The report will be directly
To be
filed.
mentioned tomorrow. To be mentioned, give notice. Where is your notice?
My lord,
You are mentioning upon notice.
my lord, this was already directed. They are also
So
aware.
what?
My lord, they are
Very well, to be mentioned, give notice to other sides.
My lord,
Give it. Application গুলো না তুমিও পরে বলে দেবো কবে দেবেন. Yes.
my lord, yesterday I had mentioned one matter, my lord, for vacating of a stay application. My lord was fixed on 8th of September. My lord, the junior was not present to hand over the mentioning slip. My lord, today the junior is present, my lord. The pile Chando. My lord, there are two other. My lord,
So
there are
what do
two
you
other.
want? What do you want?
My lord, kindly fixes it on Monday, my lord. I shall appear.
Which one? Which one to appear?
My lord, there are
Application.
two matters. Yes, my lord. One is application for vacating, and there are two other writ petitions, my lord, which I'm mentioning today, my lord.
No, I am not including the
My
writ
lord,
petitions. Only the
motion, my
application.
lord. My
Only
lord,
the
motion
application.
stage.
Application on
My lord,
Monday.
are in motion stage, my lord. Awaiting report from the state, my lord.
So let the report come, then you mention. Come
My
on.
lord, 2 weeks have.
Application.
My lord, may I be permitted to mention one matter, my lord? Am I audible?
Yes.
Yes, my lord. Yesterday I mentioned this matter, my lord. My lord, give a direction to have a talk with the council for the state that whether the report is ready or not. My lord, the report is ready, my lord. This is at motion stage, my lord, and the earlier bench direct to take up the matter immediately at the sitting of the next circuit, my lord. My lord, the report is ready.
Show me the order.
Yes,
Show
my
me the
lord.
order.
Yes, my lord. Mr. Shalok Shah is there.
Show me the order.
Shalok, kindly hand over the order.
দেখি ঠিক আছে দিন না ওইভাবেই দিন কিচ্ছু হবে না দিন
My lord, my lord, direction passed by Justice Om Narayan, Honorable Justice Om Narayan Rai, my lord. List this matter for further consideration before the next circuit bench available immediately after the expiry of the time fixed for filing report in form of affidavit, my lord.
Motion.
My lord, my lord.
Similar, my lord. It was passed by
September 10th.
Ma'am, kindly
September
allow me,
10th.
please. Yes, my lord. My lord, pardon.
Motion
My lord,
September
10.
10. Next.
My lord, my matter is
10.
also similar. It was passed by Honorable Justice
Grateful, my
Somnarayan
lord.
Rai, my lord, for filing of report within
Yes,
2 weeks.
I have taken the application. The writ
My lord,
petition will
application
be
is
later.
different. These are the 2 writ petitions that I'm mentioning right now, my lord.
No, next. Mention afterwards, madam. Let the reports come. Then.
Lordship.
Yes.
My lord, reports have come, but it is not appearing in the list, my lord.
You have been served with the report.
No, my lord, unless
Then
it is
how do
appearing
you know?
in the list.
How do
My
you
lord,
know?
because 2 weeks have already passed, my lord, for
No, the
filing of
report has
report.
come. That means report has come. Sorry, don't make these submissions. Next. Yes.
Lordship, may I be permitted to mention?
Yes.
Lordship, last Monday, 1st of September, your Lordship was kind enough to allow one mention on motion for inclusion in the list, but it's not appearing in the list till date.
I have directed, it ought to have appeared. Since it has not appeared, therefore there was no direction.
Lordship, yes, we have handed over the motion slip and we have followed up with the court officer. The number is 1318 of 2014, 24.
কোন মোশন স্লিপ বলছে হ্যান্ড ওভার করেছে অ্যাপিয়ার করেনি
WPA 1318 of 2024.
1318 WPA. Normally this doesn't happen to my court. No slip was handed over.
We have already followed up. We will send once again. I will visit the court officer.
Where is your slip? Send it. Where is your slip? Give it to me. Give it now.
Yes. Right now, I apologize. Nobody is there.
Oh, it is due to appear. It is directed to appear on 4th.
Okay,
Lordship. Already directed to appear on 4th. Lordship. That's why I said in my court, if I allow, matter appears. If I don't allow, matter will not appear.
Much obliged.
Thank you. Next. Chulun, list ডাকো. Why to be mentioned?
My lord, I beg to appear on behalf of the petitioners in item number 2 and on behalf of the private respondents in item number 1.
Why to be mentioned?
My lord, so far as item number 2 is concerned, my lord, there was a direction for filing of affidavits by the state respondents which has not been filed, and it is a hearing matter. My lord, so far as item number 1 is concerned, my lord, item number 1 arises out of the cause of action that has arisen in item number 2. May I place the facts of the case, my lord?
No, I'm not taking hearing matters. I'm not taking hearing matters because I will first complete the hearing list which is there in the list. Then I will take further matters. And yesterday the entire hearing list was called on. Nobody had done any matter. Yes.
Item number.
My lord, what I humbly submit, my lord, item 1 cannot be taken up without hearing out item number 2, your lordship.
That's right. Your learned friend on the state is saying the same thing.
Item number 2 is the hearing matter. Item number
he is saying also that first hearing item number 2 has to be heard, which is a hearing matter. Then one shall be taken up.
Yes, it is a challenge against the.
Your lordship.
All right. Ashu. In view of the orders already passed, and after hearing the submissions made on behalf of the parties, it appears that WPA 1214 of 2023, which is a hearing matter ready for hearing, has to be heard first. And then the other writ petition, WPA 336 of 2025 shall be heard. Paragraph. In view of the above, both these 2 writ petitions shall appear under the heading hearing before the second available circuit bench in the month of January 2026.
Grateful,
subject
my
to
lord.
its convenience.
Grateful.
Next. Next.
Yes, Lordship, this is three, Lordship.
Rafiq Mashi.
No, this matter is appearing for the first time. This is not regarding, this is regarding the, I'm claiming interest on the delayed payment of the commuted value of the pension.
Where is your other side?
It has been served. Now,
All right.
Lordship.
Dekho. Novankur Pal. Where is he?
Courtroom number 1.
Passed over for the day. Next.
No, Lordship, number 2 is also. This was regarding to a single PPO.
Give my order.
No, this is a. I have searched that there is no. This matter is for the first time before your Lordship.
So
Lordship
what?
has not passed any orders. I am standing with the order of justice. Another coordinate.
Oh, acha. This is the first type of.
Yeah, if you Lordship can have a look.
Single PPO, I have passed my orders.
Commuted mentioned, but number 4.
Ask Mr. Devjit Kundu.
No, I have asked him also, Lordship. Is it the first step? This is the
Double PPO. Only double.
No. 3 টা 3টাই দেখছি
3. All right, you correct the order.
Yes. If your Lordship permits this, then item number 3 to 12. These are all relating to commuted pension.
So you have to correct.
I'll correct this order.
You will. Then why the matters are included?
Corrected copy is there. Corrected copy is there. Corrected copy.
I will simply go out of the list for 6 months.
I will corrected copy. And the affidavit of service. 3.
Serial number?
3. This is item number 3.
Why? Wait. In every matter you have corrected?
Yes.
Then why you are saying you will correct?
No. I apologize. Yeah, control
আস্তে এটা other side কে দেখিয়ে নাও. Who is there? এটা 3 নম্বরে. Who is on the other side?
Mr. Pal.
Mr. Paul.
Mr. Novankur Pal, learned advocate, appears for the state. Next. এগুলো সব দেবাশিসকে দিয়ে দেবেন কারেক্ট করে.
হ্যাঁ 4 Lordship. Corrected copy. Is it
Mr. Anirban Banerjee, learned advocate with Mr. Kumar Shantanu, learned advocate, appears for the state. এই যে এখন সিনিয়র হয়ে গেছে, এখন 5 থেকে আরম্ভ করছে জুনিয়রকে. Yes.
Lordship, 5 is commuted value of pension.
My order.
No, Lordship, Achika matters.
Oh, acha 3.
Yes, those matter.
Corrected.
Yes, corrected.
Lordship, I represent.
Mr. Sumit Kumar, learned advocate for the state.
Along with Mr. Shaurav sir. Given. Grateful, Lordship.
Every order should be corrected.
Oh, corrected.
Yes, only one stand.
6 also same, Lordship.
Pritam Das.
Along with
Sorry. Along with MS Rima Sarkar, learned advocate for the state.
7 same lordship.
বিকাশ সিংহ।
Led by Mrs. Learned.
তাহলে ওনার সাহেবের নাম আগে, সুবীর কুমার সাহা, learned additional government pleader with Mr. Vikas Sinha, learned advocate.
Good.
For the state.
Same also.
মমিনুর রহমান কুমার শান্তনু।
বিপ্লব।
Those Rofik Mashi orders, that which are the matters?
This is a commuted value pension, lordship.
No, yesterday I adjourned.
Yes, lordship. Those matter are today, but it's in 26.
All right.
Later on.
Because those I will allow. I've read the next one. They are the latest judgment. Mr.
This is also a commuted value pension.
Dhar has given me that. Jagdish Prasad.
Yes,
Lordship, in item number 9, Mr. Navankur Pal. Namta, please.
Navankur Pal.
Lordship, I represent state.
Sumit Kumar. Yes.
11 also same lordship.
Who is for the state? Mr. Shubir Kumar Saha, learned additional government pleader.
Well, also the commuted value pension lordship. Lordship, I am for this.
What is the name?
I'm led by Navankur Pal.
Pratyusha Datta Chaudhary, learned advocate, led by Mr. Navankur Pal, learned advocate, appears for the state.
Wait for him.
13 also same lordship.
13.
Lord, yes, I am for the state with Saurabh Sarkar.
Pritam Das, Saurabh Sarkar.
Grateful, my lord.
You are there, madam? Madam is there?
No.
14 also lordship. This is a single PPO arrears and die-in harness matter lordship. Lordship's order only.
My order.
Yes.
Corrected.
Yes, lordship.
Lordship. Pradeep Sarkar.
Pradeep Sarkar for
Led by
state.
Hirok Burman.
Huh?
Led by Hirok Burman.
Mr. Pradeep Sarkar, learned advocate, led by Mr. Hirok Mormon, learned advocate for the state.
15 also, Lordship, this is Diane Harness, Lordship's order.
I beg to appear for the state.
MS Bedosruti Bosh, learned advocate for the state.
Lordship, for item number 16 and 17, I'm praying for next circuit, Lordship.
Why?
Lordship, the briefs are somewhere misplaced, Lordship. So I need some time, Lordship.
Come tomorrow.
Lordship, the briefs are not here, Lordship. That's why. The briefs are not here, Lordship.
It can be disposed of.
Lordship, need some time, Lordship. Kindly, Lordship.
ঠিক আছে ওর জন্য অর্ডার লেখার দরকার নেই কাম টুমরো if you don't get the brief you better take inspection of the court copy here দুটো ফাইল দুটো দিয়ে দিন এখনই দিয়ে দিন ওরা দেখে নি কি আছে you write down the relevant dates in a paper don't tear it out. Which law college you have passed out? Then you are aware of.
Well, 18
Who is there?
Yes,
Did Mr. Sudhir Kumar Shaha learned additional government leader, along with MS Pratyusha Datta Chaudhary, learned advocate.
Well, 19 single PPO.
My order.
Yes.
Shubhir Shaha, Pratyusha Datta Chaudhary, and Mr. Badhar ensure who is appearing on the other side so that he is also secure. He will also be. Ensure who is on the state for the state.
Twenty will accept single people.
Who is on for the state? Who is for the state?
Hey, we did say it.
Mr. Hirak Bormon, learned advocate, with MS Bedosruti Bosh, learned advocate, appears for the state.
Pradeep Sarkar.
Pradeep Sarkar, learned advocate, appears for the state. Bedosruti Bosh for state.
$22 million single PPO will dying hand. Widow is claiming.
My order.
Yes.
Pritam Das with Sandeep Gohara.
Pritam Das, Sandeep Gohara for state.
Yes, sir.
Corrected?
Yes.
You have taken down. So give the brief.
$23 single PPO.
My order.
Yes.
Lordship.
Vedasruti Bose with Mr. Vikas Singh, learned advocates for the state.
PPO, gratuity and arrears, Lordship, sorry.
Mominur Rahman for the state.
What one minute, Chita?
Lordship, 25 is over. Lordship, is there a big muscle?
আচ্ছা ওই অর্ডারটা দিয়ে গেছে কোনো অর্ডার কি নাম জানো আরে যেটা অ্যাপিল কোর্ট আপিল করেছে বাবা বিক্রমাদিত্য where is he just remind him
No, my lord, in 26, if my lord comes to the last page, page 21 or 1.
দেখি কি আছে
The death certificate annexed.
The
death certificate annexed with the this application. The name of the deceased is Muna Devi Pradhan, whereas the constator says Meena Devi Pradhan.
no
Yes, my lord. M-U-N-A.
cause title is Vishnu Pradhan
No, Vishnu Pradhan,
son
wife of Meena Pradhan.
Oh,
the husband has filed this application.
Big mistake, Lordship.
What type of mistake?
correct and then move
How, my lord? The PPO, kindly see the bottom, my lord. Received.
What is the name in the PPO? Does it tally with the death certificate?
My lord, the PPO is illegible, so I cannot read out.
All right.
If my lord has the legible.
আচ্ছা ঠিক আছে ছেড়ে দাও ফেরত দিয়ে দাও আসুন লিখুন affidavit of service filed in court today is taken on record. The death certificate, Mr. Learned State Counsel has raised an objection to the effect that the death certificate annexed to the writ petition shows the name as
Muna Devi Pradhan.
Muna Devi Pradhan, whereas the husband of the deceased employee has filed this writ petition on account of the employment benefit of one
Muna Devi Pradhan.
Are Muna
Vishnu Pradhan.
Meena Devi Pradhan.
M-I-N-A
M-E-E-N-A.
M-E-E-N-A Devi Pradhan. Paragraph. In view of the above, this writ petition is directed to go out of the list for the time being, and the petitioners shall take appropriate steps in the matter in accordance with law.
One more. If my lord comes to page 90, both Muna Devi Pradhan signature is there, and the form is filled with Meena Devi Pradhan. The TR form, my lord.
Sure.
27 is over, will matter, Lordship, sorry.
Rafiq Mashi, my order.
Yes.
Give it. Yes, Mr. Ghosh. देखिए दीदी की दिए Thank you. Yes, next document.
Wait. I beg to appear on behalf of the petition. Restoration application, my lord?
Within time.
No, my lord.
What is the delay?
Filed a section 5 application. There has been a delay of about 264 days.
My lord, what is the reason?
You will file affidavit?
My lord, kindly takes up
I'm
the
the respondent. I am for the respondent. Your
That's right. You are opposing the condonation application.
copy has not been served. The application.
Lord, may I affidavit of servant?
Restoration application has been not been served.
There is a delay, he is saying.
My lord, kindly cease, my lord, filed in the principal bench, subsequently transferred. My lord, I came to know immediately filed restoration application with a section 5 application.
If that will not cost 200 days delay. That might cost 30, 40, 50 days delay.
Yes, my lord. But due, I am the only
All right.
trade and
Ashun.
member, my lord, due to illness or
Which one? Which one is the? What do you say?
My lord, allow it.
Please.
Actually, how many days delay is there? How many days?
Give him a copy of the application. Come tomorrow.
My lord, since 2 days I am coming.
Then file affidavit. Come back on the next.
I'll serve.
Why? When the court is trying to give you some help, why?
My lord, I'll serve today.
That's the first thing of advocacy to be learned.
I'll personally serve my.
Here and now you give your copy, the condonation application.
Lord, only one copy. My lord, I'll serve during the course of the day. Just both the applications I have served.
You consider and come back tomorrow. Then if you, whatever you will say, I will hear you.
I'm good.
First thing is to learn the advocacy.
I apologize.
Why I have directed to serve immediately so that he can come tomorrow.
I shall come back. I am for the my lord, the alleged contempt.
Who is the petitioner?
The order, last occasion, my lord would make take the photo once.
Compliant.
Complaint.
Report filed.
Yes, ma'am.
Report filed on the last occasion.
The last.
Then why it appeared, sir?
My lord, there was a direction. They were not satisfied with the amount that we have paid to them. So there was a direction from this court that if they're not satisfied with the amount that has been paid, they have to file an affidavit and serve a copy of that to us. Till date, I have not received any copy of that affidavit. No notices.
Achha. It has been handed over.
Yes, my lord. It is there on the record of the court. Handed over. Page number, page number 2, my lord. The
Petitioner shall receive this check and the payment thereunder without prejudice.
just the paragraph report, may I read it out? The result order therefore shows certain payments are payable to the petitioner on the basis of the said result order. The learned counsel for the alleged contempt.
I have read.
Yes, my lord. Today in court has handed over a check today in court.
Today in court has handed over a check bearing number such and such for a sum of rupees such and such. The said check shall be handed over to the petitioner in course of the day.
Yes, sir, that is done.
So where do I get that? That it is done.
Well, that's giving.
The petitioner shall receive this check and the payment thereunder without prejudice to his rights and contention. How do I know you have handed over the check?
Yes, ma'am. I have a copy of the receipt too. I'll give that. And my lord, it is there in the record also. Just before sentinel, the learned counsel for the alleged contempt today in court has handed over a check drawn for a sum of learned counsel.
Today, when Kutha.
My lord, this paragraph, the reasoned order shows certain payments are payable to the petitioner on the basis of the said reasoned order. The learned counsel for the alleged contempt today in court has handed over a check bearing such, dated such, drawn on Central Bank of India, Odamtala branch, Jalpaiguri, for a sum of such.
Then again, it is written
to the learned counsel appearing for the petitioner.
The said check shall be handed over to to the petitioner.
The learned counsel for the petitioner.
Correct.
Yes, madam. That's
Ashu. None appears for the petitioner, nor any accommodation has been sought for. This is a contempt application. None appears for the petitioner, nor any accommodation has been sought for. Poster. Yes. Huh? Unmute yourself. Unmute yourself. Unmute yourself. Unmute yourself. Unmute yourself. For the day. Come tomorrow. Yeah. Ada order করুন, আসুন। ওর নাম কি লেখা রয়েছে ওখানে? One Mr. Onu, this is a content application, full stop, paragraph. One Mr. Anurag Sharma, learned advocate, appears through virtual mode on behalf of the petitioner. However, since he has not unmuted himself, and due to such technical difficulty, he is not being heard. He cannot be heard. He is not audible. First paragraph. The last order dated September 11, 2024 speaks for itself in detail, which shows that the relevant check containing the payment, containing the necessary sum, has already been handed over to the learned advocate of the petitioner who appeared on September 11, 2024. And the check was directed to be handed over to the petitioner in course of that day. Poster. Paragraph. In the said order dated September 11, 2024, it was also directed
My lord, in this case, I am for the petitioner, item 29.
Yes, what is your submission?
My lord, the purpose has been served in this contempt application.
What is your name?
My name Anurag Sharma.
This is a content proceeding, full stop, paragraph. Mr. Anurag Sharma, learned counsel, appearing for the petitioner through virtual mode, has informed this court that the grievance of the petitioner has been redressed, and as such, nothing further survives in this contempt proceeding. Paragraph. Paragraph. The last order dated September 11, 2024 speaks for itself. Paragraph. Mr. Pritam Das, learned advocate, appears for the alleged contemptor.
With objection. With objection.
Mr. Pritam Das, learned advocate, with Mr. Abhishek Sen,
Yes.
learned advocate, appears for the alleged contemptor. Paragraph. In view of the above, CPAN bold Didi, CPAN 53 of 2024 stands dropped bold and normal closed bold. Dropped and closed.
Yep.
Paragraph. Accordingly, CPAN bold 53 of 2024 stands disposed of.
Grateful, my lord.
Thank you. Thank you.
Grateful, my lord.
Next. আসুন দেখি কাগজ দেখি This is a contempt proceeding. Arising from an order of this order dated September 4, 2024 at page 29 to the application. Paragraph. None appears for the parties. Neither the alleged contemptor is represented. In view of the above, a last chance is given to the petitioner to submit in the contempt proceeding. Full stop. In the event the petitioner is not represented on the next day, it shall be presumed that the grievance of the petitioner stands redressed, and accordingly the contempt proceeding shall be dropped on the next day. কি বলি বলুন তো এগুলোকে আমরা কি প্রিন্সিপাল বেঞ্চে রিটার্নেবল হয়তো কন্টেম্প তো তাই তো হওয়া উচিত আমার কাছেই তো হবে in view of the above
item number 30 the contempt has been it has to be dropped because the order the state had preferred an appeal then the order has been set aside the single
30
yes Lordship.
This is the one.
Yes. Sorry, I missed it.
You are for the petitioner?
Yes.
Show me the order of the division bench.
I don't have.
Give me the number. Give me the number.
You kindly pass it over. I will
pass over for the day. Passed over for the day. Bring it tomorrow, so that unnecessary pendency will not. I will accordingly dispose of. Just give the appeal number and the order date, I will get it. State preferred an appeal. All right. Complied.
Already complied with, my lord.
Where is your report?
My lord, there was a direction in paragraph number 16 that it is further directed that the petitioner will remove all the deities of the aforementioned illegal construction within 7 days from today, bearing which liberty is given to the respondent number 2 to approach this court in the contempt application. My lord, as of now, no contempt petition has been stopped on the schedule in the server. We have found this matter in the list. We have taken out the server copy of the previous order and we have taken instruction.
The order dated 6th of September.
Order dated
Contempt.
8th of January 2020. This is the last one.
From where contempt arose?
My lord.
Which is the order under contempt?
Well, my lord, the copy has not been served, my lord, but the last order which was passed by Honorable Justice
6th of September. By?
Honorable Justice Partho Sharathi Sen.
How? Contempt? Contempt.
There are two matters, my lord.
Sir, I am on one contempt, which is before me, and it shows that it arose from 6th of September 2024, passed by me. Has to be.
My lord, in 31, the certificate number 2 of 2025.
Yes.
Arising out of WPA number 13 of 2024.
Yes. The order dated 6th of September 2024.
Subsequently, there was one more order. That is order dated 8th of January 2025.
Where is that, sir?
May I hand over the server copy of the order?
Please. But the contempt arose from 6th of September, which is my order.
Take an inquiry and all. Subsequently, inquiry was done, hearing was provided, directions were given to remove the illegal construction. In accordance to that, then again, the matter was taken up for inquiry. Subsequently, this last order.
Disposed of.
It has been disposed of. Yeah, our discussion that the thing has been removed. The small temple which was there, that has been.
It is further directed that Achadana. January 8, 2025. আর এটা ছিল None appears for the petitioner nor any accommodation has been sought for. Mr. Sir, your name? Bijoy Bikram Das. Excellent name. Bijoy Bikram. Mr. Bijoy Bikram Das, learned advocate, with Mr. Devorshidhar. Who is senior? You are senior. Devorshidhar, learned advocate, appears for the alleged. Sir, cannot be alleged contemner. Who is the alleged contemner?
Copy has not been held.
The alleged, one second. The alleged contemners. Oh, here the writ petitioner is the contemner. Yes. Taken out by Poli Shaha. It doesn't matter. কি বললাম? আর উপরে লিখেছে none appears. চলো আমি রাউন্ডেড শেষ করে কি বললাম? এবার লিখুন. The instant contempt proceeding arose from an interlocutory order. Interlocutory kotota bold. Order kotota bold. Interlocutory order dated June 20, 2024. Annexure P1 at page 19 to the contempt application. Paragraph. Learned counsel, paragraph. Learned counsel appearing for the contemner, alleged contemners has placed a judgment dated January 8, 2025, asked by a coordinate bench, whereunder the entire writ petition was disposed of. Copy of the judgment is taken on record. Paragraph. Doesn't matter. Paragraph. Once the writ petition has been disposed of finally, the interim order dated September 6, 2024 has merged with it. Full stop. After such merger, the contempt proceeding is not maintainable, comma, in the considered view of this court. Paragraph. Inasmuch as since the petitioners are not since the petitioner is not represented today, comma, the court presumes that petitioner does not intend to proceed with this contempt proceeding any further. Paragraph. In view of the above, the instant contempt proceeding, bold CPAN 2 of 2025 stands dropped and closed. Paragraph. Accordingly, CPAN 2 of 2025 stands disposed of. Sure.
Madam, for the petitioner.
Yes.
My lord, kindly take page.
First day?
Yes.
Appearing first day?
Yes.
This is a contempt proceeding arising from an order dated
27th January 2025.
January 27, 2025. আচ্ছা ওদের ওপরে লিখুন মিস্টার
Ajay Singhal. Ajay Singhal.
Ajay Singhal, learned advocate, appears for the petition. তারপর লিখছেন ওটা তারপর কি লিখলেন the instant is না arising না কি বলেছেন full stop. Today is the first day. তো আপনি জানেন এবার. Paragraph. The petitioner is directed to serve a copy of the contempt proceeding along with a copy of today's order. How many? Upon the alleged contemners, and shall file affidavit of service when the matter shall be taken up next. Paragraph. Pendency of this contempt proceeding shall not preclude the alleged contemners to comply with the direction of this court and to file a compliance report on the next day. Poster. However, in the event of non-compliance, comma, this court may proceed on the next day for issuance of rule. Paragraph. the matter shall appear under the heading contempt application on
Monday.
December 19, 2025.
My lord, we can serve it by hand.
Next. Normally, my experience, if a slightly longer time is given with this observation, it's carried out.
My lord, may I make a submission, my lord? My lord, they have flouted the order. That is why we have come before, my lord, because my lord had directed the SDO to take consequential
So
steps.
they will not be given an opportunity.
My lord, everything has done, my lord. Now he has said that.
So what do you expect me to do on the first day in a contempt?
My lord,
Tell me the law.
yes, my lord, if it can be taken up on Monday, my lord, it's of urgency, my lord, because the restaurant is being run in an illegal building 24/7, my lord. Because the husband of the private opposite party is an influential person and a police officer, my lord.
That's neither here nor there.
For that reason, they are taking these steps, my lord. They are
Give some
safeguarding
time.
them. My
Give
lord.
some time. Give some time. Give some time. ঠিক আছে। আচ্ছা, one second. September 11 করে দিন, দেখা যাক। September 11, 2025. Yes.
I'm appearing on behalf of the petitioner, my lord, affidavit of such. My lord, this matter pertains to the admitted claim of the contractor, my lord. The petitioner participated in a tender process and.
Who is the respondent?
My lord, the Tufanganj municipality responded.
Yes. Municipality, how much?
22 lakhs 90,000.
Pay by tomorrow.
My lord, my lord, we pick up page number 54. We have made several requests to the joint secretary and responded number 4.
Page.
Page 50, from 49 onward, but I am taking from assembly. From 54, my lord, the first request which we have made in the year 2020.
50?
54.
Fund has not been released.
Yes, the second request has been made in page number 51. Non-release.
Did they reply?
No. 3 years, my lord, I am running from pillar. And the last request we have made in the year 2025, January. And
Wait, which page? Which page?
Page number, my lord, the third request, page number 49.
Acha. Wait. And the last request of January?
Yes, my lord.
Last request of January?
Page January 2025.
Page
49.
49, yes. 49. So 2 requests.
3 requests.
It's the third one, second one, show me. Page.
Second one, page number 51. 22nd August. 22nd August 2023. And an acknowledgement to that effect has also been annexed in the division. Despite of that, number 52, page number 52. No payment.
Acknowledgement by?
By in the respondent number 4. Urban Development and Municipal Affairs, affairs, Calcutta, my lord. The work completed, my lord, 2022, my lord. More than 3 years, I am running from pillar.
Show me the work order.
My lord, sheet page number 21, my lord, is the work order.
Arising out of a tender process. Acha, লিখুন এইভাবে লিখুন। Mr.
Devayan Goswami.
Devayan
Goswami.
Goswami, learned advocate, appears for the petitioner. Mr.
শতরুদ্রীয় মুখার্জি। শতরুদ্রীয় এসে
রুদ্র রুদ্র তোমার প্রখর দীপ্তি বুঝেছেন? শত
কপিরাইট টু দিস
ঋত্য।
No, none has at least in this code. Neither the school I study.
শতঋত্য ঠিক আছে হলো। For respondent number 9 stroke the municipal corporation. Who's for state? Mr. Hirok Bormon, learned advocate, with Mr. Saurabh Sarkar, learned advocate, appears for state. The petitioner states that arising out of a tender process, a work order was issued, dated, come on, which page?
Page number 21, my lord. 26th of September 2018. Page number 21.
6 September 20?
26th September. 26
Page number?
21, my lord.
It is November.
The last.
Yes. Wait. কি বললাম? A work order was issued dated September 26, 2018 in favor of the petitioner for carrying out certain civil construction work. Show me the completion certificate.
My lordship, it is in page number 24.
The entire work has been done. এই যে বাসুবাবু কেমন আছেন? How are you? হ্যাঁ, শরীর ভালো আছে এখন? হ্যাঁ, জ্বর কমেছে? আসেনি তো? ঠিক আছে, বসুন।
My lord, first installment has already been.
Please. কি বললাম? The entire work has been completed by the petitioner to the satisfaction of the municipality.
My lord.
As would be evident from the work completion certificate dated
2 September 2019.
Page
24. This is the completion of my first work, first RAB. This is my first completion certificate.
And the last?
And the last one.
Completion certificates.
And
dated, come on slowly. Dated first one?
First one is, my lord, 2 September 2019.
Page
24. Page 20.
Slowly.
My lord.
September 2, 2019 at page 24 to the writ petition. And the last one is?
Page number 39, my lord.
Dated? Slowly.
My lord. 6th of May 2022.
May 6, 2022 at page 39 to the writ petition. No objection or demur was raised as against the work done by the petitioner, by the municipality. The petitioner has raised its running bills and a part payment for a sum of rupees.
Ending, my lord, 22 lakhs 90,000. My lord,
48,000.
22 lakh 48,000.
Part payment
Of 22 lakh
of 22 lakh
48,000.
48,000 has been made as to the petitioner in pro tanto satisfaction of the claim of the petitioner, as would be evident from page.
My lordship, the page number 39. There is a reflection.
As would be evident from page 39 to the writ petition. The petitioner claims the balance amount of rupees
22 lakhs 90,039.
229039. Paragraph. Learned Counsel, Mr. ওই নামটা আর একবার লিখো।
Rudriyo Mukherjee.
Appearing for the concerned municipality has drawn attention of this court to pages to the requests, to various requests dated March 2, 2020 at page 54 to the writ petition. August 22, 2023 at page 51 to the writ petition. And the last one, January 10, 2025 at page 49 to the writ petition. Made before the
Joint Secretary, my lord.
respondent number, joint.
Three.
Respondent number 3 for release of fund so that
An acknowledgement has also been made.
so that the entire balance claim of the petitioner can be paid off, as the municipality is satisfied with the total work, with the work completely done by the petitioner arising out of the said work order. The office of the respondent number 3 has also issued an acknowledgement in this regard dated August 23, 2023.
Respondent number 4.
Oh,
UDMA.
the respondent number 4 করে দিন।
UDMA 4 তো? হ্যাঁ, 4.
Respondent number 4 কি বলেছি?
Director.
An acknowledgement in this regard 2023 at page 52 to the writ petition. Paragraph. Yes, Mr. State.
Funds are not given for a particular project because general fund are be placed for with different municipalities. They have issued the work order, burden lies upon the.
Learned Counsel, Mr. Hirok Bormon, appearing for the state, submits funds are not sanctioned project-wise, but in bulk against a particular municipality. Then,
And then this whether this we have placed request for fund and that has been acknowledged. Acknowledgement not acknowledgement of the for sanctioning the amount as demanded, but as per the detailed scrutiny and government approval. That is our letter.
unless further government approval is received,
Work was that is also to be looked to whether these works were done with the approval of the department.
after the work is done. Very well. কি বললাম? Further, since government approval has not been received, fund could not be released. Full stop. These are your submission. Paragraph. After considering the rival contentions of the parties and upon perusal of the materials on record, the series of events stated above would show the admission of jural relationship between the municipality and the petitioner. Full stop. To the effect, full stop not, to the effect that the municipality had issued the tender and the work order in favor of the petitioner, and the petitioner has completed the work without any objection raised by the municipality. Thus, the entire work has been admitted to have been executed to the satisfaction of the municipality without any objection. Full stop. Paragraph. When the tender was floated and the work order is issued, and the work has been done successfully, it is the legal obligation on the part of the municipality to make the to pay the entire billed amount to the petitioner. More so, when the part payment has been met in
Connection to the what?
in the year.
Yeah, 19, 1. In 2018, madam.
In 2018, it shows the admission of liability and acknowledgement of the work done towards the petitioner. At this juncture, neither the state nor the municipality can deny to release the balance payment, which is otherwise an admitted sum. Paragraph. In the facts of this case, since an admitted sum is due and payable to the petitioner, such sum is the property of the petitioner. And the withholding of it without due process of law is a clear violation of the right guaranteed under Constitution to the petitioner. Paragraph. In view of the above, the balance sum of rupees 22
lakhs 90,000.
90,000
39.
shall have to be paid and released, and paid in favor of the petitioner forthwith. Which respondents first?
My lordship, inquisition has been made before the joint secretary, respondent number 3. And
basic liabilities of the municipality.
Sir, who will release?
We have not admitted.
All right, who will release?
Means chairman has first given the work order.
So who will release?
Chairman will release the amount as demanded because they have.
So who will release in favor of the municipality? In view of the above, don't worry. In view of the above, the following directions are met. Roman 1. In the event, it is the responsibility of the respondent number 3 and 4 to release the fund in favor of the municipality for making necessary payment in favor of the petitioner, then the respondent number 3 and 4 shall release the fund in favor of the
because sanction fund, general fund, they have to go through the fund and seek approval. Suppose they give 10 work orders without
carry out. Go before the appropriate. Let me pass my direction. Let me pass my direction.
Without having any fund, they are giving work orders.
All right, let me see. Ki bolna? In the facts of this case, then the respondent number 3 and 4 shall release the said fund to the extent of 22
lakhs 90,000 39.
একবার বলছো ভাই 90,000, একবার ওখানে বলছো 39. What is this?
22 lakhs 90,039. That is I'm saying 39.
You have said that the 22 lakhs 90,000 only.
The second
Which is the total sum?
কত টাকা বাকি আছে?
22 lakhs 90,030.
039.
03.
So why you have said the 900, 90,000? ওই যেখানে অ্যামাউন্টটা লিখুন, ওপরে একটা বোল্ড করে লিখুন, ভুল হলে হবে না। দিস ইজ টু মাচ। 22 lakhs
90,000.
90,039। ঠিক আছে, এটা ওই ওপরেও হয়ে যাবে। কি বললাম? In favor of the respondent number 9.
Municipal corporation.
Stroke the relevant municipal corporation positively within 4 weeks from the date of communication of this order. Roman 2. In the event the respondent number 3 and 4 is of the opinion that it is not their responsibility to release the fund in favor of the respondent concerned municipality, then they shall inform the same with reasons in writing to the municipality and the petitioner positively within a period of 2 weeks from the date of communication of this order. Roman 3. In the event fund is released by the respondent number 3 and 4 as directed above in favor of the municipality, then the municipality / respondent number 9 shall forthwith pay the petitioner a sum of the said sum. আচ্ছা না, উপরে চলে যান তো, ওই ডিরেকশন গুলোর আগে কি বলেছে? Along with interest at the rate of 6% per annum since the last date of part payment dated
Second September 2019, my lord.
page
Page 24, at the completion certificate it is there.
part payment.
Part payment.
What was the amount of part payment?
22 lakhs 41, my lord.
Page.
Page 39 in the second RA bill, full details are there. Page 39, my lord.
When was it paid?
Date is not there. Date is not there.
Well, to my instruction, it was 2019.
Instruction. ওরকম হবে না, তুই তো অর্ডার অ্যাপিলেই যাবে না, আমার বেঁধে লিখতে হবে। করলাম at the rate of 6% per annum. Very well. You show me the first letter to the.
It's my lord on page 54.
Since.
Letter of request, my lord.
Since the first letter of request dated March 2, 2020 at page 54 to the writ petition till the date of actual payment to be made to the petitioner. তারপরে কি বলে 6% গুলো ইন্টারেস্ট এগুলো বোল্ড করবেন, বলুন।
Then fund by the respondent numbers 3 and 4 as directed above
না একটু আগে থেকে পড়ুন ফলোইং ডিরেকশন আচ্ছা একটু আগের প্যারাগ্রাফটা পড়ুন যেখানে ইন্টারেস্টটা ঢোকাল পড়ুন তুমি মেট টু দ্য পিটিশন তারপর paragraph, huh? Zero to above. As directed above.
The fact of this then the responding of must be on board shall be interesting fund to the extent of the
along with interest.
Of the responding number
Oblique.
The corporation. For the from the date of competition of this order. The responding number 4 is of the opinion that
Is of the opinion.
it is not their responsibility to release a fund to the municipality. If they shall inform the state the presence that given the accident and the petition that for the spelling and the petition positively influence from the date of communication of this order. Number 3, the intent found is referenced by the responding numbers 3 and 4.
Along with above income fund is released ঠিক আছে কোড বলো দরকার ঠিক আছে চলছে
By the responding numbers
in the event the fund comma as directed above comma
by the responding numbers 3 and 4 as they shall
said sum by crediting the bank account of the petitioner positively within a period of 2 weeks from the date of receiving the fund from the respondent number 3 and 4. Paragraph. Next. Roman. In the event it is found that it is not, in the event the respondent number 3 and 4 is of the opinion that it is not their responsibility to release the fund and it is the sole responsibility of the municipality to pay the petitioner, comma, then the municipality, concerned municipality stroke respondent number 9 shall pay the entire amount with interest as directed above to the petitioner positively within a period of 4 weeks by crediting the bank account of the petitioner from the date of receiving the communication from the respondent number 3 and 4. 3 and 4. Full stop. Paragraphs. Even regular paragraph. These directions are mandatory and peremptory. That's all.
My lord, may I interject at one point, my lord? My lord, the local municipality body is subjected to the release of funds from the state government. May that be respondent number 3, the joint secretary, may that be urban
Mr.
affairs.
Counsel, I have recorded your submission and I have made the alternative as well.
My lord,
So let them decide and do the needful.
my lord.
These directions are mandatory and peremptory. Full stop. Yes, Mr. Borman, what more?
My lord, that last line is very dangerous for me. That last line is very dangerous because if they deny to pay ultimately, then
He has to be, sir, the work you have consumed has to be paid.
No, my lord, that tender has been floated by the
Okay,
government.
sir. I have passed my direction. Whoever will be the responsible has to pay. It is basically, be it municipality, be it these 3 and 4, these are the arms of the single umbrella of the state.
No, my lord, we are the hands and they are the heart and the brain.
Absolutely.
And if the hand is immobile due to non-transfer of blood, then stroke hitting the hand won't work, man.
No, but if the heart if the heart becomes weak,
yes,
but
then,
the hand
then the
becomes
treatment has to
strong.
go- yes, is my lord.
But the hands are strong.
Yes.
Chalo, next. কি বললাম? Paragraph. Since affidavits are not called for, the allegations made in this writ petition are deemed not to have been admitted by the respondents. Paragraph. With the above observations and directions, this writ petition, bold, WPA 1746 of 2025 stands disposed of, without any order as to cost. Huh? Key?
No, my mistake. My mistake.
Thank you. You should have come up with your plea of jural relationship. I'm coming within the let me see.
Lordship, I am on behalf of the petitioner, Lordship. Lordship, I filed this application regarding the illegal construction over the ancestral property of the petitioner.
At the behest of the private respondents.
Lordship, the private respondents are said to be.
Where is your affidavit of service?
Lordship, affidavit and service.
You have served the private respondents.
I have served the private respondent. All have been duly served, Lordship. Lordship, my representation is at page number 33.
33.
Lordship, I am appearing for the private respondent 3, 4, 5, and 6. Lordship, I seek an opportunity to file affidavit in opposition.
Thank you.
My lord, we are appearing on behalf of the Siliguri Municipal Corporation.
Affidavit of service filed in court today is taken on record. Mr. Your name, sir?
Satyam Sarkar. Sattam Sarkar.
Sattam Sarkar, learned advocate, appears for the petitioner. Mr. Bijoy Bikram Das, learned advocate with Mr.
Devorshidhar.
Dhar. Devorshidhar, learned advocate, appears for respondent numbers
1 and 2.
1 and 2 dash slash Siliguri Municipal Corporation. Mr. Amit Shah, learned advocate, appears for the private respondent numbers 3 to 6. All private respondents.
No, there is one more.
There is another private respondent number 7. It's not being present.
Full stop. 3 to 6. Tapol likhun. The private respondent number 7 is not represented, comma, despite notice. Who shall visit?
The engineer has been, assistant engineer has not been made up.
Doesn't matter. So
The
long.
assistant engineer will
Yes.
visit.
So long the municipal corporation serves the purpose. Ashun. The petitioner alleges illegal and unauthorized construction at the behest of the private respondents at the subject premises. Paragraph. The the petitioner has submitted his representation dated April 11, 2025. The petitioner her representation dated April 11, 2025, annexure P4 at page 33 to the writ petition.
As well as the reminder. There is a reminder. There is a reminder letter also.
Followed by a reminder dated
13th May 2025.
May 13,
2025.
at page
35.
35 to the writ petition. But the same have not been disposed of. Paragraph. In view of the above, the jurisdictional
Assistant
assistant engineer
Siliguri Municipal Corporation.
of the respondent number 1 upon issuing a prior hearing notice of 3 working days on the petitioner and all the private respondents shall inspect the said alleged unauthorized and illegal construction at the subject premises, and then shall draw up a report with the necessary sketch map with reference to the sanction plan of the subject premises. The report shall be served upon the petitioner and all the private respondents. Paragraph. This exercise shall be carried out and completed by the jurisdictional assistant engineer positively within a period of 2 weeks from the date of communication of this order. Paragraph. The report shall also be placed before the respondent number 2 by the assistant engineer. Paragraph. The respondent number 2 then, upon a prior notice of hearing of at least 7 days to the petitioner and all the private respondents, and after granting them an opportunity of hearing, shall decide the issue in the light of the representation dated April 11, 2025, Annexure P4 at page 33 to the writ petition, followed by the said reminder of the petitioner, and then shall pass a reasoned order in accordance with law. Paragraph. This exercise shall be carried out and completed by the respondent number 2 positively within a period of 4 weeks from the date of receiving the report of from the assistant engineer, jurisdictional assistant engineer. 6 weeks, 6 weeks.
Deeply applied.
Post. The reasoned order then shall be communicated. Basu, period go looking to bold 2 weeks. Shall be communicated to the petitioner and all the private respondents positively within a further period of 1 week from the date of the said reasoned order shall be passed. It is needless to mention that the private respondents shall be entitled to participate in the hearing before the respondent number 2 through their duly authorized representative. Full stop. Full stop. It is made clear that this court has not gone into the merits of the claims and rival claims of the petitioner and the private respondents, and they shall be at liberty to urge whatever points they wish to urge by relying upon whatever records and documents they wish to rely upon before the respondent number 2. But the same shall not travel beyond the scope of the said representation dated April 11, 2025. Paragraph. In the event the reasoned order confirms the unauthorized and illegal construction, who shall take step? Commission. The respondent number 2 shall take all necessary and consequential steps to give an immediate effect to the said reasoned order in accordance with law, but positively within a period of 3 weeks from the date of the said reasoned order to be passed. Paragraph. In the event of removal and demolition of any alleged unauthorized construction, if police assistance is sought for by the respondent number 2 and or the appropriate authority of the municipal commission, municipal corporation, comma, the local police authority shall provide all necessary assistance in this regard to execute the work of the municipal corporation. First one. That's all. That's all. Paragraph. Since affidavits are not called for, the allegations made in this writ petition are deemed not to have been admitted by the respondents. Paragraph. With the above observations and directions, this writ petition, bold, WPA 1447 ঠিক আছে তাহলে ভুল লিখেছো কেন বাবা এখানে
Victor
1747 of 2025 stands disposed of without any order as to costs. Paragraph. Leave is granted to the learned advocate on record for the petitioner to correct the writ petition number on the affidavit of service by putting his signature thereupon.
Item number
Grateful,
30, I have got the order. The MAT order set as
30. Come tomorrow. Pass over. You give it so that my officer can download it here and now. The printout niye naw to baba. Sahiber kaছ থেকে নিয়ে. I'm coming within 10 minutes. সাহেবের কাছ থেকে নম্বরটা নিয়ে printout নিয়ে.
Beautiful.
Item number 35.
এটা কি? হ্যাঁ, এটা তো কালকে আসবে। হ্যাঁ, ঠিক আছে, অ্যাপিল হোক না, তাতে কি হয়েছে? ঠিক আছে, এটা কোনটাই ছিল? আরে বাবা, হ্যাঁ, এটা তো রাখতে হবে, পড়ে নেবো, তারপর রেখে ওই ফাইলে গেছে দেখো। হ্যাঁ, ঠিক আছে।
Item 35, I beg to appear for the petitioner. Lordship, this is a writ petition application which is preferred against the cancellation of registration of a GST registration. Lordship, this is a matter praying for that.
Who is on the other side?
On the other side, Mr. Bishwaraj Agarwal appeared the other day. Mr.
Customer for the day, you just inform him, I will take up tomorrow.
Tomorrow, Lordship.
Passed over, next.
Next, Lordship.
And you collect my order I have passed yesterday,
Yes,
my
Lordship,
judgment.
that I have contained, I have brought that today. Already.
Next.
I'm for the petitioner led by Mr. Pratim Mukherjee.
You give it to him also if necessary, so that if you wish to rely upon, so that.
Already.
Yes, yes, yes. Next.
My lord, I appeal for the petitioner.
And I'm for the respondent of 5, my lord.
Yes.
Lord, in a nutshell, my lord, I'll place.
Who is for the petitioner?
My lord, I am for the petitioner.
Huh?
I am for the petitioner.
Yes.
Yes. My lord, in a nutshell, I'll place it, my lord. My lord, kindly first comes to page 23. That is the previous order passed by this honorable court. This is the second round of litigation, my lord.
Show me 13th August.
The impugned order. No, that is at, yes, that is at page.
Page 13, my lord.
Page 13.
Page
13, 13.
Page 13. Yes.
Now, my lord, kindly sees the order. No, this is an absolute cryptic order without application of any mind. No, the basis of the rejection is not at all tenable in the eyes of law, not in view of the judgments which have been pronounced by this honorable court. Now, the issue is no more res integra. The ground taken by relying on Rule 4 subclause B, Lord, is no more permissible.
Okay, let us read it. Let us read it. Place it, place it, read
yes,
it.
Lord. Yes, yes. Lord, I'll only place the relevant portion, my lord.
No, you place it from the beginning.
My lord, the petitioner is an assistant teacher of Dobogram GSF School, Shiliguri, Naxalbari Circle since 27/2021. Since her permanent residence is at village Khonnan, PO Itachuna, PS Pandua, District Hooghly, she is seeking transfer under DPSC Hooghly and filed WPA number 690 of 2025. She filed the instant writ petition and the Honorable Justice Hirmay Bhattacharya has been pleased to dispose of the writ petition on such and such with the following directions. Without entering into the merits of the claim of the petitioner for transfer, WPA number such and such is disposed of by directing the President, West Bengal Board of Primary Education to consider the representation of the petitioner dated 12 December 2024 in terms of the relevant rules and to pass a reasoned order. In case the said authority decides in favor of the petitioner, consequential steps shall be taken thereafter. Accordingly, the petitioner has submitted representation to the board and in compliance of the aforesaid solemn order, the matter has been taken into consideration. The petitioner was given an opportunity of hearing on 15th of May 2025, vide the office memo number such and such dated 8th of May 2025, and the petitioner attended the said hearing. All the information records, relevant rules, government orders, and verbal submissions of the petitioner appellant at the time of hearing have been taken into consideration, and the following particulars have been observed. Now, my lord, this is the basis. The petitioner is serving as an assistant teacher at such and such school, Siliguri, Naxalbari, Siliguri since 27/2021. in terms of the appointment letter issued by the PSC Shiliguri Wide Memo such and such. Her permanent residence is at village Khonnan, PO Itachuna, PS Pandua, district Hugli, PIN such and such, and the distance between her permanent residence and workplace is approximately 522 kilometers. So, my lord, I had sought for transfer on special grounds. I am a lady having 2 children and one is a breastfeeding child. Now, reference has been made to Rule 4B of the West Bengal Primary Education Transfer of Teachers, including Head Teacher Rules 2002 and its amended notification such and such dated 13/9/2021. It is clearly stated that on an application from a teacher, a transfer approved teacher within its jurisdiction from one primary school to another primary school on the condition that such approved teacher in case of mutual transfer is confirmed and in case of single transfer is confirmed and has completed minimum 5 years of continuous service. I pause here for a moment. This rule does not apply to me.
Wait. When was your application?
My application was made on just
12 December 2024.
12 December 2024.
So 5 years you have not completed.
Not completed. I need not require to. That is my argument, legal argument.
Show me.
Why I say so, my lord? Now kindly
give me the rule.
My lord, I'll hand over the judgment of the Honorable High Court.
First, give me the rule.
I'll tell your lordship why this rule is not applicable.
So first, let me read the rule, then I will see why it is not applicable. Unless I see the rule, how do I know?
Lord, my learned junior is there, my lord, if he can assist.
Yes, he is handing it over. He is giving.
It's a 2002 rule.
West Bengal Primary Education Transfer of Teachers, including Head Teacher Rules 2002. Now, Rule 4B. Let's read Rule 4. Condition for transfer. You read.
Yes, my lord. A council may on its motion or...
Slowly. On its motion or...
which is now under consideration, B, on an application from a teacher, transfer approved teacher within its jurisdiction from one primary school to another primary schools on the condition that such approved teacher is confirmed and has completed minimum 2 years of continuous service, both in case of mutual or single transfer, provided that the council may, if it fits, considers necessary for proper utilization of service of a primary teacher in the interest of education, transfer an approved teacher without maintaining any time limit of service, provided that there is a surplus teacher according to role strength, as stated in Rule 3. The council may, on its motion, transfer such approved teacher without maintaining any time limit of service by way of rational adjustment of teacher in a primary school having deficit teacher in the following order of preference. That is a primary school without an approved teacher, a primary school having a single teacher, and other primary school having shortage of teacher. So this is the rule which is under reference. Now, my lord, why I say this is not applicable, even without the judgment, is because of the fact it is with the transfer within the same district and not an inter-district transfer. Here I am seeking a transfer from Shiliguri to Hugli. So if your lordship kindly...
Show me from the rule that it is within the same district.
Yes, my lord. My lord, kindly looks into 8.
Huh?
No, Rule 8. My lord, the same rule. Rule 8. Inter-council transfer. Has your lordship found it, my lord?
Yes.
In case of inter-council transfer, the council shall follow the principles and procedures of the board in accordance with the provisions conferred by Clause K of Section 19 of the Act.
inter-council transfer. What does it mean?
My lord, in my humble opinion, my lord, it is
One
within
district to another.
one district to another, my lord.
Inter-council transfer.
Now, my lord, may I place the judgment of the Honorable High Court, the division bench judgment, my lord, which has taken into consideration everything.
Now, first, let me understand that why 4 and why 4B will not apply.
Lord, 4B will not apply because, my lord, I am seeking transfer from one district to another first.
Right.
Second
Where is
is,
the
my
4B says that it is intra-district, within the district.
lord, it says within its jurisdiction. So,
on an
my lord,
application of a teacher, teacher approved teacher within its jurisdiction.
so, my lord, within its jurisdiction means every district primary school council has its own jurisdiction. Because the procedure is once I am transferred to another council, another district, I will
So
be issued.
you say that since you say that for every district there is a council.
Yes, yes.
District's primary school council or secondary
every district
So
has
for every district, it has got its own council.
own council.
Therefore, you are saying that council may, on an
Language,
application
yes,
from a teacher
within its jurisdiction.
within its jurisdiction, which means when
That
a
is-
council, which means according to you, when a council receives an application from a teacher, it has to consider the transfer if it is within its jurisdiction.
Yes.
Very
If it is not, then it is to be decided by the board. It's more like a section 24, section 25 principle.
So your case is that it is to be decided by the board.
And
your
accordingly,
case is council has no jurisdiction. It has to be decided by the board.
And
Now,
accordingly, my lord,
first,
yes.
and the order of the coordinate bench is also that president of the
Yes,
board.
yes. That is why.
Now the order has been passed by Secretary West Bengal Primary Education.
There is no difficulty. So the appropriate person has passed the order.
Right.
The difficulty is the application of this rule. This rule will not apply to me.
Acha, show me the judgment.
Yes. Now, my lord, kindly takes up. My lord, my learned junior will hand over. Purva Danke.
He has.
Yes.
Handed over.
My lord, may I place it?
Yes.
I'll place it, my lord, from the very beginning. Though there is no reflection of any provision putting a restriction and or embargo of 5 years in seeking transfer, yet it can be reasonably inferred that what weighed to the single bench was a rule 6 of the Kolkata I'm sorry, my lord, rule 6 of the West Bengal Primary Education Transfer of Teachers Rule, including Head Teacher Rules 2002, hereafter referred to as the said rules. The said rules, my lord. Rule 6 of the said rules is explicit that no teacher shall be eligible to apply for transfer for a period of 5 years from the date of
For a period
transfer.
of 5 years?
Which the rules which your lordship was considering just now, which according to the learned advocate for the board is extended to 7 years, such being the undisputed facts discerned in course of hearing. The first and foremost point which arose before us, whether such rule has any manner of applicability in the facts of the instant case. That's the question of law, has to be decided, which is similar to my facts.
Now, in the judgment, what was the case for transfer? Intra-district or
No,
inter?
Inter-district.
From one district to another. I'll show the facts. Let me place the entire judgment. The said rule is promulgated in exercise of powers conferred under Clause K of subsection 2 of Section 106 of the West Bengal Primary Education Act, containing exhaustive provision relating to the transfer of teachers, including the head teacher. Sub-rule 2 of Rule 1 of the said rule clearly indicates that the said rule shall apply to teachers, including head teacher, for the purpose of transfer from one primary school to another within the jurisdiction of a council, which, my lord, we had just now shown to your lordship.
Within the jurisdiction of
This
a
is,
council,
yes,
which
this
means within the same district.
within the same district. Now moving forward, it is explicit from the aforesaid provisions that the aforesaid rule has its applicability to a transfer from one primary school to another within the territorial jurisdiction of the respective primary school council and does not expand its horizon to a case of transfer from one territorial jurisdiction of a council to another territorial jurisdiction of a council. The aforesaid provision appears to have been overlooked. Had those been brought to the notice of the single bench, probably the said order would not have been passed. Now, this is the important part. It is no longer res integra that the moment the subordinate legislation or substantive legislation is promulgated to operate within a limited contour, its operation cannot transgress such limit, but has its applicability within the limited sphere. The stand of the council that an embargo of 5 years or 7 years is created in processing an application does not appear to be in consonance with the law applicable in this regard. Our attention is drawn to section 19 subclause 1 subclause K of the West Bengal Primary Education Act 1973, being the repository of the powers and functions of the board, including the power to transfer any teacher or non-teaching staff from a primary school within the jurisdiction of one primary school council to a primary school council within the jurisdiction of another primary school council, which is our case. Such power is vested upon the board in case of transfer is sought from one zone to another, or in other words, from one primary school situated under the one primary school council to another primary school council, and therefore, in such situation, the respective primary school council does not have any powers or jurisdiction to deal with such application for transfer.
It's the board.
It's the board. So now comes the operative part. The executive instructions in form of principles and procedures to process the said application is also 3 subsequently notified by the secretary of the board with a notification dated 2nd November 1991. It contains an exhaustive provision relating
My lord,
to...
sorry to interrupt. Can you have what?
Yes.
May I proceed? It contains an exhaustive provision relating to principles and procedures to be adopted on an application taken out by a teaching or non-teaching staff of a primary school seeking transfer from a school situated within the jurisdiction of one primary school to a school situated within the jurisdiction of another primary school. It does not contain any embargo like the one appearing in the said rules. Therefore, the order assailed in the instant appeal based upon the said rules, which lacks its applicability to the facts of the instant case, is unsustainable. The impugned order is thus set aside. The secretary of the board is directed to consider the said application in light of the notification dated November 2, 1991 as amended from time to time, and a conscious decision shall be taken. So that is why, my lord, I say that in case of a transfer on special grounds, and more so if it is on the issue of to a transfer to a different district council, Lord, with deepest of respect, Lord, the rules of 2002 does not apply. And that is why the basis of rejection is also bad.
Yes,
and
sir.
What is more astounding, if I may put it in this way, my lord, your lordship will go through the entire petition and your lordship will find the exercise which has been performed by the, kindly comes to page 27 onwards. Now this is the exercise which they have, the secretary of the board makes a communication to the chairman with regard to the people teacher strength of the petitioner school. Now, in response to that,
sir, these are really doesn't matter. These really don't matter.
Yes.
I have to adjudicate whether the impugned order is sustainable or not. If I find it
On
is
that
not
score.
sustainable, it will be quashed. It will be sent for further consideration strict in terms of
Yes.
the law.
By
Yes.
holding that this rule is not applicable.
That's right, of course. Otherwise, why this impugned order should go? If it goes. Yes.
Man, I'm appearing for the West Bengal Board of Primary Education.
You are appearing for?
Oh, West Bengal Board of Primary Education.
Yes.
May I audible?
Yes, yes. You sustain.
Malad,
You have
actually,
to.
Malad,
You
I
have
was
to
waiting.
sustain the impugned order.
I'm just coming, Malad. Actually, I was waiting for Malad item number 37. Since I joined Malad, I have seen this matter, Malad, but I was not, the board was not probably served. Malad, actually, I have not received the brief from the board, but I have heard my learned friend. Malad, I just assist your lordship. Malad, there are, Malad, the 2002 rules was amended in 2021. Malad, when the Honorable Division Bench, Malad heard this, and Malad, my learned friend has cited the judgment of the Division Bench. Malad, just a month after when the rule was placed before the Division Bench, the amended rule, then the judgment was slightly modified. Not this judgment, the another judgment, the holding that this rule is very much applicable.
Show me the amendment.
Malad, right, the amendment, Malad, right now, Malad, I am not, Malad, since I was not in this matter, because that is why, Malad, I can assist your lordship, kindly take it up tomorrow, so that I can, Malad, hand over the rules and, Malad, the judgment.
Tomorrow, passed over.
Malad, I'm grateful, Malad.
Subject to correction, if I may ask to Mr. Bishwas, if you can give the citation of the judgment, what he is referring to, then, my lord, I can do my homework on that.
I will.
And you, Mr. Bishwas, you must produce the Xerox copy of the judgment.
I try my level best, your lordship. I will assist your lordship tomorrow by Malad.
No, if you don't produce, how will I read?
Yeah, no, definitely, Malad. I definitely, Malad, I will. Definitely, Malad. Otherwise, I cannot assist your lordship.
Is this the judgment of Monica Mehta? Is this the judgment of Honorable Justice Harish Tandon in a division bench?
Monica Mehta.
Well, the judgment I referred to was Justice Tandon's judgment.
Yes.
No, judgment. The petitioner has already referred to. Petitioner has referred to the judgment. Dekhi ki judgment dekhi?
I have referred to Purvodon.
Malad, that Purvada judgment, what my learned friend is referring.
Recent judgment 2025.
Bring tomorrow.
Yeah, sure.
Yes.
Grateful to your lordship.
Next.
My lord, for the petitioner, my lord, this is the transfer, my lord, of
Malad, one thing, Malad, just Malad, I'm disturbing your lordship, Malad, one thing, Malad, the copy of the restitution may be served upon you so that I can assist properly assist your lordship, Malad.
He has not been served.
No, my lord, this.
No, not this matter, Malad, the earlier matter.
Earlier what, my lord?
Oh, earlier matter.
Malad, the board has been served. Perhaps Mr. Bishwas has not received it from the board, but I can give him a soft copy.
Give him a mail.
Millard, in item number 36, Millard, the board has, Millard, instructed me to appear in this matter. Millard, however, since Mr. Bishwas is there, Millard, he is my senior. Millard, I will probably he can procure a copy from Mr. Mukherjee in Calcutta and will assist the court. I will assist him here. No difficulty.
Malad, very well. I will.
And I will send
give
him
a
mail.
Copy? Yes.
I can only send him a mail, Malad.
Okay, I definitely. Grateful.
Yes.
37 is a transfer of a primary school teacher, inter-district primary.
Inter,
your lordship.
So one district to another.
Yes, Alipurduar DPSC to Murshidabad DPSC on the ground of distance and medical lodges.
Impugned order passed.
No.
Rejected.
This is for the correction.
No, yesterday your lordship has passed the order.
We have already corrected. Only the name of the advocate appearing for the state is to be written. My lord. Otherwise, your lordship has passed.
Who is on the other side?
But I am appearing for the board.
Well, that is not applicable in case of inter-district transfer. That is.
My lord, I am
inter-district
appearing for the
transfer.
board.
Huh.
Oh, for consideration.
Yes, your lord.
Yes, for consideration.
Yesterday, your
This is
lordship has passed the, my lord, favoring lordship, my lord, kindly pass the order, my lord.
আচ্ছা,
Same order.
appearance গুলো লিখুন।
My lord, the state, my lord.
হ্যাঁ, সুমন সেন, ওইগুলো লেখাই আছে।
State.
Wait. প্রাইমারি বোর্ড হচ্ছে রাতুল বিশ্বাস অ্যাডভোকেট থ্রু ভিসি।
And Vikramaditya Ghosh. Oh, DPS.
আচ্ছা, বিক্রমাদিত্য ঘোষ এটাই নেই, রাতুল বিশ্বাস আছে থ্রু বিশ্বাস। আচ্ছা, ডিপিএসসি আলিপুরদুয়ার বিক্রমাদিত্য ঘোষ উইথ প্রবল বিক্রম।
And state, my lord, with.
Anirban Banerjee and Pradeep Sharma.
অনির্বাণ ব্যানার্জি উইথ মিস্টার প্রদীপ সরকার, learned advocates appear for the state and in the
Next lordship, same, my lord, I am seeking transfer from Kuch Bihar DPSC to Murshidabad DPSC.
Who is appearing?
I am appearing, my lord.
DPSC Kuch Bihar, my lord.
আচ্ছা,
My lord, I am appearing for the board, my lord, all the matters.
রাতুল বিশ্বাস for
Board, my lord.
board আর MS
Mousumi Bhawal
for
DPSC Kuch Bihar.
DPSC কুচবিহার।
মনে নাই দাদা।
রিমা সরকার, learned advocate with Mr. Pritam Das, learned advocate for the state.
Affidavit of service.
Yes.
এটা পরেরটা। Affidavit of service. 39 হবে।
My lord, in 39, I am appealing.
39.
I am appealing for the DPSC Kuch
38
Bihar.
38 হয়ে গেল।
38 অমিবাবু
38, 37.
হ্যাঁ, ঠিক আছে, আস্তে আস্তে করুন না, কোনো চাপ নেই। 38 কে কে অ্যাপিয়ার করছে? সরকার ফর স্টেট আর রাতুল বিশ্বাস ফর বোর্ড আর মৌসুম ভাওয়াল ফর ডিপিএসসি
Kuch Bihar.
কুচবিহার।
Kuch Bihar, my lord.
রিমা সরকার, প্রীতম দাস।
My lord, I have already given the my lord, necessary changes in the order of your lordship. Nine. 39 lordship, Kuch Bihar DPSC to Murshidabad DPSC.
ওই রাতুল বিশ্বাস ফর বোর্ড, মৌসুমি ভাওয়াল ফর কুচবিহার ডিপিএসসি স্টেটে, মমিনুর রহমান উইথ কুমার শান্তনু স্টেট।
কত 41, 42?
All these for consideration.
Yes, your lordship.
Yes, my lord. My lord, the 41 and 42 is also, my lord, identical. I believe my longest friend is appearing.
No, one by one. Yes, next.
40 is another thing, another matter.
40. Acha.
They are appearing for.
So let us do 41 and 42.
Well, I'll be withdrawing the application.
You will be withdrawing. Excellent. Come on. On the prayer of Mr. Nabankur Pal.
Facts have been missed, my lord. I want to file it after.
On the prayer of Mr. Nabankur Pal, comma, leave is granted to withdraw the granted to the petitioner to withdraw this writ petition and to file afresh on the self same cause of action
With better particulars.
with better particulars, comma, as according to him, those particulars are not stated in the writ petition but relevant for adjudication. Mr. K. Opurpokhe.
My lord, I am for the respondent numbers 6 and 9.
Mr.
My lord, Shubham Ghosh.
Shubham Ghosh, learned advocate, appears for respondent numbers
6 and 9.
6 and 9.
Mr. Vijay Vikram Das.
Vijay Vikram Das, learned advocate, with Mr. Devorshidhar, learned advocate, appears for
Respondent number 1, 2, and 3.
respondent number 1, PO 23.
7 and yes.
আর কেউ আছে? Anybody else?
A small indulgence, I'm for 6 and 7. 6 and 7.
7. Anybody else? Anybody else? In view of the above, the writ petition bold number WPA
WPA 1766 of 2025
stands dismissed as withdrawn with liberty to file afresh on the self-same cause of action and self-same set of facts with better particulars.
Grateful.
Chul.
State case 41 Lordship Kuchbihar DPSC to North 24 Pargana DPSC.
Ratul Bishwas for the board. Mousumi Bhawal for Kuchbihar DPSC.
Yes, madam.
Hirok Bormon, Vikas Singho.
Hirok Bormon, Vikas Singho for state. Next. এগুলো সব J2 হয়ে যাবে, হ্যাঁ? Next. Next.
Malad Kuchbihar DPSC to Murshidabad.
আচ্ছা, রাতুল বিশ্বাস for the board, Kuchbihar DPSC, Mousumi Bhawal. Mr. Shubir Kumar Shahal and an additional government feeder for the state.
Madam, I'm grateful, Malad. Malad, kindly excuse me, Malad. I'm appearing to DC, Malad. I couldn't appear.
No, it's all right.
Malad, I'm grateful, Lord.
Thank you.
Lordship, one indulgence if I may. Lordship, in the item number 35, Lordship.
Should I go back?
No, Lordship, it's all.
I'm appearing
Unauthorized construction.
No, no, no. Milord, I am only praying, Milord, consideration of my representation at
For
page
what?
45.
For what?
Milord, I have constructed a residential building. Now, with passage of time, since it was a commercially lucrative area, a portion of that building, Milord, was converted for commercial use.
For regularization.
For regularization, there is a provision in the act. I have to pay them a revised fees upon demand. Let them cause an inspection because there is a cap on the floor limit which I can convert for commercial use. So I am within that. So we'll let them cause an inspection, make the appropriate demand, Milord, we will pay. Milord, page 45 is my representation. Milord, the provision is 273A that is quoted in my representation. If Milord desires to have a look, Milord.
45.
Yes.
Annexure P10.
Ashun. Affidavit of service filed in court today is taken on record. Of J2. Mr. Vikramaditya Ghosh, Learned Counsel, appears for the petitioner. Mr. Vijay Vikram Dash, Learned Advocate, with Mr. Devorshi Dhar, Learned Advocate, appears for respondent numbers.
All the respondents.
Respondents / Shiliguri
Municipal
Corporation. Paragraph. The petitioner submits that the petitioner has converted a portion of the subject premises as a commercial area. The petitioner submits that he has submitted its representation dated May 16, 2025, Annexure P10 at page 45 to the writ petition. for regularization of such construction of commercial area, comma, which is otherwise permitted in law, comma, but the said representation has not yet been considered. Paragraph. Come on, show me which respondent shall inspect.
The Commissioner Municipal Corporation.
He will not inspect.
No, but he may be directed to consider, he will cause the inspection.
Respondent number 4, the executive engineer.
Full stop. Paragraph. In view of the above, the respondent number 4 is directed upon a prior notice to the petitioner to cause the necessary inspection of the subject premises and the alleged commercial area constructed thereat in strict compliance of the statutory provisions, and then to file a report with the relevant sketch map, comma, if necessary, to the petitioner and the respondent number 3. Paragraph. This exercise shall be carried out and completed by the respondent number 4 positively within a period of 4 weeks from the date of communication of this order. Paragraph. Upon receiving the report from the respondent number 4, comma, the respondent number 3, upon serving a prior hearing notice of at least 7 days to the petitioner, and after affording an opportunity of hearing to him, shall consider the said representation dated May 16, 2025, annexure P10 at page 45 to the writ petition by passing a reasoned order in accordance with law. Paragraph. It is made clear that this court has not gone into the merits of the claim of the petitioner, and the petitioner shall be entitled to urge whatever points he wishes to urge by relying upon whatever records and documents he wishes to rely upon before the respondent number 3. But the same shall not travel beyond the scope of the said representation dated May 16, 2025, comma, as referred to above. Poster. Paragraph. In the event the reasoned decision goes in favor of the petitioner, the respondent number 3 and or any other appropriate authority of the municipal corporation shall take all necessary and consequential steps strictly in accordance with law. And subject to compliance of all the legal formalities, an effect shall be given to the said reasoned order. Poster. Paragraph. In the event the reasoned order, now, in the event the petitioner does not succeed to his claim before the respondent number 3, the respondent number 3 shall be at liberty to take steps immediately in accordance with law against the construction caused by the petitioner.
The construction is otherwise legal according to the
But I don't know. If it is legal, it is legal. If it is illegal
Grateful.
and cannot be regularized, it will be demolished.
Right.
They have made prayers for change of usage from residential to commercial.
He has made construction, whatever you consider the representation. If you find it is done, it can be done, do it. If it is found it is not to be done, to what extent not to be done, go and remove or don't allow, matter ends.
Grateful.
Take all necessary and consequential steps immediately against the construction / user caused by the petitioner. Paragraph. Paragraph. This order shall not, it is made clear that this order shall not create any right or equity in favor of the petitioner, comma, if the petitioner does not succeed to his claim before the respondent number 3, strictly in accordance with law. Paragraph. এর আগের প্যারাগ্রাফটা পড়ুন। Caused by the petitioner, but positively within a period of 4 weeks from the date of the said reasoned order to be passed. তারপরে তো যা বলেছি ইকুইটি হবে না, রাইট হবে না, প্যারাগ্রাফ। Since affidavits are not called for, the allegations made in this writ petition are deemed not to have been admitted by the respondents. Paragraph. With the above observations and directions, this writ petition WPA 1775 bold hobe, of 2025 stands disposed of, comma, without any order as to costs.
Is it order to be passed within the period of?
দেখে নিচ্ছি কি বললাম, চলে যান ওই রেসপন্ডেন্ট নাম্বার চলে যান, ওই আপন রিসিভিং দ্য রিপোর্ট পড়তে থাকুন। And after affording an opportunity. তলা একটা রাইডার ঢুকিয়ে দিন। This exercise shall be carried out and completed by the respondent number 3. Commissioner 3. Positively within a period of 4 weeks, 6 weeks from the date of receiving the report from the respondent number 4. Full stop. The reasoned order shall be communicated to the petitioner within a period of 1 week from the date of the said reasoned order to be passed. Sure. Okay. চলুন ঘুরে আসি। Yes. Next circuit. Ashu, on the pair of MS, Tania Bhumik, learned advocate appearing for the petitioner, comma, since service has not yet been effected, comma, the writ petition shall appear under the heading new motion before the next available circuit bench. Paragraph, the petitioner shall file affidavit of service. Next. Service complete.
Yes, this is a police inaction matter.
Police in action. Service complete.
Service upon the state and the.
Where is the police?
I have served upon the state.
Really কি আছে? Police in action.
Okay, if you logic kindly takes up my.
What happened? You are beaten up and a counter complaint.
No. In this, what has happened, Lordship, the petitioner, he has made a complaint of online fraud. Total amount of rupees 8,15,600. She was introduced by 2%.
Forget it. Not on the merit of complaint.
Not on the merit of the complaint.
What inaction on the part of the
inaction
police?
of the police is that if the complaint was lodged on 25
Page.
June 2024, page 60.
16.
But till
The police has come.
Yes, police. Till today's Lordship, no recovery, nothing. What step they have taken?
No recovery.
No.
They have lodged FIR.
If
What is the police case number?
Yes, police. Yes, cyber crime. That to the
কোথায়?
Siliguri
Police case number.
Lordship. Cyber crime police station.
Where?
One of
Acha. Mr. Learned and affidavit service filed in court today is taken on record. Paragraph, Mr. Debashidhar, learned advocate, appears for the petitioner. Mr. Shondip Gora, learned advocate, led by Mr. MS Vedashruti Bose, learned advocate, appears for the state. Alleging a cyber crime. The petitioner has lodged complaint before the jurisdictional police station. Full stop. The petitioner alleges since then the police authority is inactive and the adequate step has not been taken after receiving the complaint. Paragraph. Annexure P1 at page 16 to the writ petition is the FIR registered by the jurisdictional police authority. Paragraph. Learned State Council has submitted a police report. Submitted a police report dated August 30, 2025, issued by the Commissioner of Police, Siliguri Police Commissionerate. Enclosing several documents and records. The same is taken on record. Full stop. Paragraph. The said report divulges that police case number
64 of 2024.
Give me the number. Where? The description.
FIR number 64.
FIR number, any police case lodged?
Yes, FIR number.
Oh, FIR number.
FIR number 64 of 2024, dated 25th June 2024, under sections 419.
Once. The FIR shows that charges are already registered under the relevant provisions of the criminal law. Being FIR number
64 of 2024.
64 of 2024, dated
25th June 2024.
June 25, 2024. The report divulges further that notice under section 41 what এখনো CRP huh? Oh, 2024. Notice under section 41 of Code of Criminal Procedure, 1973. 1973. Corresponding to section 3 bracket 5 bracket close of BNSS have already been issued. And the police authority has been moving with utmost expedition. Paragraph. In view of the above, the jurisdictional police authority is directed to conduct the necessary inquiry and investigation as expeditiously as possible and to conclude the same within a period of 2 months. 2 months from the date of communication of this order, and then to submit charge sheet, comma, if it is necessary to be submitted in law, comma, within 2 weeks from the date of conclusion of such investigation before the jurisdictional criminal court. Poster, paragraph. The jurisdictional criminal court in that event shall expedite the criminal trial so that a logical conclusion can come in accordance with law as expeditiously as possible. Paragraph. It is made clear that this court has not gone into the merits of the criminal charges alleged by the petitioner. Full stop. The police authority and the jurisdictional criminal court shall be free to proceed independently, but in accordance with law. Paragraph. Since affidavits are not called for, the allegations made in this writ petition are deemed not to have been admitted by the respondents. Paragraph. With the above observations and directions, this writ petition bold WPA 1777 of 2025 stands disposed of, comma, without any order announced. মাথার উপরই affidavit of service লেখা আছে? Thank you. Why? দেখি এটা ধরতেই হবে, বুঝে গেছে কিছু পাবে না। Withdraw it. Let the disposal be added to my list.
Proper instructions come.
14B of which act?
The Provident Funds Act.
Eh?
Provident Funds Act. 19.
Without deposit, without preferring the appeal.
I may have to. I have only bring on next set.
দেখেছেন জানি appeal for 7I appeal, deposit. On the prayer of Mr. Devorshi Dhar, learned advocate appearing for the petitioner, the writ petition shall appear before the next available circuit bench under the heading motion. Paragraph, none appears for the respondents. Paragraph, petitioner shall serve notice upon the respondents and file an affidavit of service when the matter shall be taken up next.
Yes, for the petitioner, Lordship, this is with regard to removal of encroachment from the PWD land. Oh, sorry.
Your phone? Where is the private respondent?
Sir,
Ashur, dekhi.
now, Lordship, kindly comes to page number 59. This is our representation.
Show me representation.
Page number 59.
Ashur, affidavit of service.
No, there's something more to it. After this representation was filed, they took no steps.
Who took? Who is for the PWD?
They appeared on the last occasion.
You are appearing. State is represented.
Now, kindly come to page number 63. In the earlier round of litigation, already there was a direction upon the concerned
Assistant engineer.
Public Works Department assistant engineer to
Jurisdictional assistant engineer.
To cause a inspection and take steps in accordance with in terms of section 10 of the West Bengal Highways Act. And Lordship, they came for an inspection, but subsequently no steps have been taken.
Then it's a contempt.
No. Subsequently, page number 65, kindly comes to page number 65. They have served me a letter saying that apropos to the above mentioned subject, the undersigned is forwarded herewith with the above mentioned copy to him, as this is not under his jurisdiction. And the same, he says that the area where this enforcement does not fall within in his jurisdiction. So I have to move this fresh. I have to find this fresh. Now let them say the who will be the appropriate authority.
Ashur.
But may I suggest? Let them direct them to file a report, Lordship.
I will direct the appropriate jurisdictional authority shall carry out the order of Justice Sinha.
Lordship. What is time for time bound?
Ashur. This is the second round of তার আগে দেবশ্রী ধর petitioner তারপর ওদিকে হচ্ছে রিমা সরকার led by Mr. Nabankur Pal, learned advocate for the state. Affidavit service filed in court today is where is affidavit service? Affidavit service filed in court today is taken on record. Paragraph. This is the second round of writ litigation on the same set of facts. In the first paragraph, in the first round of writ petition, WPA 849 of 2025, a coordinate bench by its order dated April 22, 2025, Annexure P5 at page 63 to the writ petition has disposed of the writ petition, directing the jurisdictional assistant engineer PWD to take steps in accordance with law as mentioned therein.
That is the executive engineer.
Executive engineer. Poster. Paragraph. Mr. Devorshi Dhar, learned advocate appearing for the petitioner, draws attention of this court to a communication dated May 22, 2025. Annexure P6 at page 65 to the writ petition and submits that the concerned executive engineer PWD informed that he has no jurisdiction.
Is 6 over it? It's 1 over 6.
Informed that he had no jurisdiction on the subject matter, being the subject alleged encroachment on PWD land. Paragraph. In view of the above, who shall be directed? Respondent number
6, the Chief Engineer PWD, North Zone Jalpaiguri Division.
He shall carry out.
He shall. I have taken instructions from my client that he is the
jurisdictional authority. In view of the above, the jurisdictional authority being respondent number 6, comma, as learned counsel for the petitioner has informed this court, comma, shall carry out the direction of the coordinate bench dated April 22, 2025 in its true spirit and effect.
ছয় তো ছয় ছয় না তুমিও জিজ্ঞেস করছো আমরা তো জানি ছয় নাকি আরেকটা
Full stop. The time period mentioned in the said order dated April 22, 2025 shall reckon from today. Full stop. Paragraph. This, it is made clear. Huh? Acha. The time period, ki bolum? Shall reckon from the date of communication of this order to the respondent number 6. Full stop. Paragraph. It is made clear that this court has not gone into the merits of the writ petition. Full stop. Paragraph. Same as above. No part of the order. Same as above. No part of the said order dated April 22, 2025 has not been modified and remains unaltered.
May I indicate one thing? In case the respondent number 6 again says that it does not fall within his also.
এর কোনো শেষ নেই বাবা।
No. The question may I? No. Whatever. He may
আচ্ছা,
direct.
কি বললাম শুরুতে বলুন as this court has been informed বলেছি না হ্যাঁ ও নিজেই শিওর নয় and or the appropriate jurisdictional authority lordship. Paragraph. Since affidavits are not called for, the allegations made in this writ petition are deemed not to have been admitted by the respondents. Paragraph. With the above observations and directions, this writ petition number ta bold kore din stands disposed of. Comma without any order is to cost. Next. Yes.
তো দিয়েছি তুমি state
48.
Lordship, 48 is so we are take instruction. Income tax matter.
Income tax matter, you will take instruction. Ashun. Mr. Devorshi Dhar, learned advocate, appears for the petitioner. Paragraph. On the prayer of Mr.
Saurabh, led by
Saurabh
Kaur,
learned advocate, led by Mr.
Pradeep Shah.
Where is he? Pradeep Shah, learned advocate, appearing for respondent numbers.
India also
Appearing for respondent.
State also respond. State was it?
Respondent numbers. One Q 27.
127.
The writ petition shall appear
127. Next week.
before the next available circuit bench. Before the next available circuit bench under the heading motion, comma, subject to its convenience. Paragraph. Mr. Who is representing state? Mr. Hirok Bormon and learned and Mr. Pradeep Sarkar, learned advocate, appears for the state.
Next circuit.
Next.
I'm applying for school. No, school.
Is answering respondent again.
Where is this?
But I have sent one, it has not yet been delivered.
All right.
Can you take it on Tuesday?
Next circuit.
Tuesday.
Next.
Small point involved, Malo.
Next.
Monday or Tuesday, Malo.
Mr. Navankur Park
Not today, then, Malo. Let me time I left.
passed over for the day. 50.
Item number 50, Lordship, I am for the petition.
Who is on the other side?
The state respondents are there.
State.
State.
My lord. At taking information, Rasmus BLR have not paid the proper Rasmus.
BLR has not.
They are not the answering respondent. The answering respondent is.
They are paid party. They have been paid party.
Who is the answering respondent?
Yes. The answering respondent is Lordship, kindly takes page number 28.
Who is the answering respondent? Cost
The
title.
answering respondent, Lordship, the additional district magistrate and DLRO.
Respondent number 5 and? 5 and?
5.
And?
Hi, Guru.
Additional.
They are claiming for LTS, long-term settlement.
Response number 5. Additional district magistrate and district land reforms officer.
DLR.
5.
DLR.
The state is representing them.
Additional and respondent of 5 and?
Respondent number 5. Then he is the person, the district magistrate. If your Lordship kindly takes to the earlier order passed by the district magistrate, Jalpaiguri, 25.
He has refused.
No, he has not refused. He has stated that on payment of rupees 35 lakhs and on some
Pay off.
we are ready to pay. We are ready to pay. Kindly come to the earlier round on what Justice Sinha had passed. Kindly come to page number 26. This is the order passed by the earlier coordinate bench. The petitioner is in occupation of vested land, such and such, Lordship.
Show me that they have said
Yes, page
35
number
lakhs.
27.
Huh?
Page number 27, the district magistrate Jalpaiguri is directed to intimate the follow-up steps required to be taken by the petitioner for obtaining the long-term settlement of the subject land. Such
Right.
intimation.
Then what happened?
Then Lordship, page number 20th, he has stated that
Has been sent.
it has been sent to
Has
the.
been sent, not yet.
It has been sent to the land and land reforms department. Copy of the RR department, but this they have stated on 4th October 2024, and since then they are keeping silence on the issue. This question only said what steps you have taken. We are ready to pay the rent. We are ready to pay the.
That is not intimated to you.
Not.
You have said 35 lakhs. Show me they have demanded 35 lakhs and you're ready to pay.
Yes, they have demanded the 35 lakhs. And you said takes page number 425. They have accessed market value of 1 acre of land, 35 lakhs. Market value of the proposed land.
That is the proposal has been sent
No, this has been given to.
by the DM.
Yes, we are ready to pay.
You may be ready to pay, but where is the demand from their side? That you pay 35 lakhs, we are executing the deed.
That is what, let them say what steps they have taken.
Acha, kindly come, sir. You come to page 28. This was addressed to whom?
To me.
28.
28. Yes. She is the petitioner.
Yes, it has been sent to.
One second.
In compliance of the last.
Wait.
টাকা পাবো না, টাকা দেবো। টাকাও দেবো, সার্ভিসও করবো। জিপি না।
Kindly come to the last sentence, sir. Kindly come to the last sentence. Steps may be taken in accordance with the said policy. Right? Who shall take the step?
The department shall say.
Give me the respondent number or an authority. DM.
No, DM has already sent the proposal.
So who shall take the step? You tell me. Respond number 2. Tell me. Yes, Mr. Shaha, who shall take the step? Principal Secretary.
Respond number 3.
Principal Secretary.
Secretary has not been made a part.
Of course, Principal Secretary is made a party. He will take steps.
Yes.
Ashu.
Is the policy of the government? They are not.
Correct. So let them take a step and inform him within 3 months.
Yes.
That this much.
Not-
Ashun. Affidavit of service filed in court today is taken on record. Mr. Devorshidha, learned advocate, appears for the petitioner. Mr. Shubir Kumar Shaha, learned additional government pleader, along with Mr. Hirok Bormon, learned advocate, appears for the state. Learned counsel for the petitioner has drawn attention of this court to the order of the coordinate bench dated September 23, 2024, Annexure P7 at page 26 to the writ petition. Passed by the coordinate bench in the previous round of writ litigation. He then draws attention of this court to the communication dated October 4, 2024, Annexure P8 at page 28 to the writ petition, issued by the respondent number 5. Post paragraph. It appears from the said communication dated October 4, 2024, that the steps has to be taken in terms of the claim made by the petitioner for long-term settlement of the subject land, following the relevant policy decision of the state. Post paragraph. Learned advocate for the petitioner submits. What you are calculating? How much you have received today?
No.
Submits that calculate করে যাচ্ছে কোন কোন মক্কেল কটা ফি দিল গুণ করে যাচ্ছে কি বললাম submits that thereafter no further step has been taken and the matter rests RESTS at that stage. Paragraph. This court has been informed that Principal Secretary, Department of Land and Land Reforms and Refugee Relief and Rehabilitation Department.
Number 2.
Is the appropriate authority through whom the state has been impleaded in this writ petition to take the appropriate decision. Paragraph. In view of the above, the said Principal Secretary, as described against the respondent number 2 in the cause title, shall decide the issue in the light of the prevailing policy decisions of the state, and then shall pass a reasoned order in accordance with law and inform the same to the petitioner. Poster. Paragraph. The entire exercise shall be carried out and completed by the said Principal Secretary, Principal Secretary within 3 months from the date of communication of this order. Within the said period, the decision of the Principal Secretary shall also be communicated to the petitioner. Paragraph. it is made clear that this court has not gone into the merits of the writ petition or the claim of the petitioner, and the principal secretary shall take his decision independently in the light of the prevailing policy decisions of the state, but in accordance with law. Paragraph. Since affidavits are not called for, the allegations made in this writ petition are deemed not to have been admitted by the respondents. Paragraph. With the above observations and directions, this writ petition both stands disposed of, without any order as to cost.
Great.
Lordship, in 51, I am for the respondent 4 to 6, 4 and 6, Lordship. CGST. Answering respondent is state, Lordship.
May this please your Lordship. My Lord, this is a matter of GST. Now, before Lordship gets into the thicks of the brief, let me put the case in a nutshell. What has happened, my Lord?
You are asking for an interim order?
Yes. There's an adjudication. This adjudication in a GST, under the GST regime, it is followed by two notices. One is a pre-show cause notice. The other one is a show cause notice. Lordship knows better than me, my Lord. Now, what happened here, they had issued a pre-show cause notice. I will bring your Lordship to that pre-show cause notice, and Lordship will see that the notice itself is as vague as the word vague can be. Thereafter follows the show cause notice. That is also as vague and as confusing as it can be.
So, the moment show cause notice has already been issued, the previous notice has merged with the show cause notice.
True. But one and the other are same. I will show, my Lord. Now, thereafter I filed a rectification. In the rectification, just on my hunches that these might be the reasons.
So you have replied to the show cause?
Yes, I did. And thereafter I filed a rectification as well of the adjudication order. There, my Lord, I got out of 4 points. In 3 points, I got relief. But 1 point stood, and in the appellate order, that was again an unmindful order, my Lord. Nothing was considered. But before I proceed, my Lord, first I should state before your Lordship, there is a small error in the, I shouldn't say illegality, but an irregularity certainly. The show cause notices should have been challenged in the prayer portion. It has not been challenged. That, my Lord, I'm at the very beginning, I'm stating.
You have challenged?
I've challenged the adjudicating order. Yes. Very well. I'm grateful to one. Lordship kindly comes to page 33.
You have replied to the show cause. You have submitted to the show cause.
Yes. But
now
the show cause
adjudication, very well, but the adjudication order has come.
My Lord.
Even if you have a right to take point that the show cause was bad.
True.
I'm sure you should have taken before the adjudicating authority.
Yes.
Therefore, no further requirement for challenging show cause.
Grateful. My Lord, kindly comes to
if
page
the adjudication goes,
everything goes. True. Lordship kindly comes to page 33, that is annexure P1. This is the pre-show cause notice. I would trouble your Lordship with the
page
33, my Lord. The pre-show cause notice at page 33.
Where is your affidavit of service?
No. My Lord. My Lord, my respondents are appearing, both of them. May I please? Grateful. Subject, case proceeding, reference number so-and-so, intimation of liability under section so-and-so, brief fact of the case, short payment of tax, comma, ITC. This is written IIC, but it's ITC. ITC availed in excess and interest payable. We're not pausing here for a moment. Under the GST regime, there cannot be any other offense. Short payment of tax, ITC mismatch, or rather ITC availed in excess, and interest payable on the same. There cannot be anything else thereafter. Please refer to the above proceedings. In this regard, the amount of tax interest penalty payable by you under section 73(5) with references to the said case ascertained. A table is given. A table is given, and thereafter the grounds, and on the next page, the grounds and quantification are attached, given below. Short payment of tax, and then on the next page thereafter, 34. That is the ground.
The ground and qualifications are
Attached, and thereafter short payment of tax, ITC availed in excess and interest payable. Thereafter is that attachment on that page 35. On the next page, these are the cyclostyle pages. Now comes the actual, which should have been the actual questions. Now, my lord, kindly peruse here. The table below shows the summary of discrepancies noticed during the scrutiny of returns, GSTR 3B, furnished by you with reference to the information available, if any. This is dated, my lord, 11/7/2023. My lord, reference to, and thereafter reference date of case creation, my lord says. Page 35 I am referring to.
Oh yes, April. No, that's the period.
Yes, that's the period. Just before that period, 11/7/2023. So now, thereafter, the table. Yes. Huh? Ki bolcho?
Where?
This is signed on 24th date, but the case creation, the date of case creation, when everything started snowballing, was 11/7/2023. But that is, be that as it may, my lord. Now, the table below shows the summary of.
What is this document called?
My lord, this is the annexure to the pre-show cause notice, which is supposed to bring out the allegations against me so that I can answer. Now, my lord, kindly peruses the nature of this document. This document is supposed to provide me with a guideline that how and why I should pay or where I went wrong. Now, the table below is very well, madam. The table below shows the summary of discrepancies noticed during the scrutiny of returns, that is GSTR 3B, furnished by you with reference to the informations available, if any, in your GSTR 1, 2A, 9 and GSTR 9s. My lord, this portion.
The table below show the summary of discrepancies.
Yes.
Noticed during scrutiny of returns.
So they have made a scrutiny of return. And
published by you.
And they have
reference to the information available.
Yes.
If in your GST 1, GST 2A, GST 9, GST.
Now let me elucidate, my lord. GSTR 3B is the return that I file. GSTR 1 is the statement that I file. 2A is generated, auto-populated. If I am purchasing from somebody, his 1 becomes my 2A. And thereafter, 9 is the reconciliation, annual return, and 9C is the reconciliation. So they have comparatively studied that, and what they have found? Tax short paid on outward supply. I'm not pausing here for a moment. Is it possible for any person to answer, as per my calculation, there is no shortage. As per their calculation, there is a shortage. You simply give me an amount, a quantum. How do I explain? I have nothing in my hands, my lord. And thereafter, same goes with ITC availed in excess. Now, I do not know where from they're getting these figures. So, I am severely handicapped in making a cogent reply. And thereafter, they have calculated the interest. And lordship now kindly turns to the next page, because that is the end of the table. Details of the discrepancies have already sent to the RTP, but the RTP has not replied or explained the discrepancies.
What is RTP?
RTP is me, the registered taxable person. I have not replied, but this notice cannot be replied. Any sort of this, and thereafter they have once again given me a show cause notice.
And the show cause?
Thereafter, in the next page, my lord.
Show cause dated?
This will be found at page number 42, which is dated.
Because it's 42.
42, my lord.
31/8/20.
31, yes, August 31, 2023.
Page 42.
42. Before that, my lord, I should say, in the middle, there were a few pages with tables. I'm not troubling your lordship with those tables because those tables are also one after one allegations and quantum noted. So it is not at all possible for me to answer. And thereafter starts this page, because if your lordship wants to see that once, please, if that.
So I'm at page 42.
Yes, but before page 42, my lord, the whatever I showed, that pre-show cause notice has not yet been ended. Thereafter, there were a few more pages of more tables saying you have done this for rupees so and so. But I do not have any inkling as to how they're.
So let us now
42, on 42, yes. I'm placing it. Yes, I'm placing it. Brief facts. Short payment of tax, ITC availed in excess, interest payable. End of the story. Nothing thereafter. Grounds, short payment of tax, ITC availed in excess, interest payable. Again that table. Only the gisted figures, my lord. And thereafter, my lord, sees the next page 43. That is the biggest shocker. Here, my lord kindly sees there's a smaller table at the end, left-hand side, at the bottom. Date by which reply is to be furnished, submitted.
NA.
Yes, yes.
My judgment.
Yes, yes, yes. There is lordship's judgment as well. Yes. In fact,
Forgive me.
I do not have it because they've challenged this and
I will. I am not ready with your lordship's judgment, but I had one judgment on the same point delivered by Honorable Justice Joy Sengupta.
I did my in the last circuit. Mr. You appeared, sir.
Lordship.
Give me the judgment, my judgment. You appeared, I remember. In the in the month of January or something.
January.
When I last sat in the circuit.
Lordship, I am just checking, Lordship.
Check
Just-
it up. Check it up. And my judgment is there.
Yes.
Achha, very well. Then you furnished your reply.
My lord, I could not furnish my reply in so many terms. I visited the office in search of
Have
documents.
you furnished your reply?
My lord, I could not have because no, I did not. I only prayed for certain adjournments. That cannot be treated as a reply.
No. So
Yes.
you did not furnish your reply
Yes.
because of the inadequacy.
Inadequacy in the question itself.
And the date of personal hearing is not applicable.
Not applicable, venue not applicable. So I couldn't have even gone there.
I have my judgment.
Yes, yes, yes.
I do not have it on me today.
Joy Sengupta judgment পাঠাতে বলো তো।
No, I have my own.
Well, today they are challenging the appeal.
No, I am challenging from the very beginning, from the very inception.
Very well. Show me the appellate order, what points
Yes.
you have taken and how have they decided.
My lord will come to page number
Page?
70. 70?
8.
7.
No, first you show me the adjudication of the
Yes,
order.
yes.
You have challenged this before the adjudicating authority.
No, this is the adjudicating authority's handiwork.
Okay. So straightway from this you went to appeal.
Appeal, statutory appeal, the first statutory appeal.
Show me.
Lordship wants to see the adjudicating order or the appellate order?
The adjudicating order
Very,
dated.
very well. My lord, the adjudicating order is page number 46.
Dated?
Dated 4/10/23. I'm thankful to my learned friend. I'm severely handicapped today.
4/10/23.
Yes, this is the adjudicating order at page 46. Lordship will forgive me, I could not carry the brief, it got lost in the transit, my lord.
Come tomorrow then?
No, I'm here. I have my e-brief here. ট্যাবটা পর্যন্ত ফেলে চলে এলাম, মানে হয়।
If you wish, you can come tomorrow.
No, my lord,
Be passing it over.
my lord, I've come from Calcutta, so.
Adjudicating order 46.
Page 46. May I place? May I place, my lord? Yes. A show cause notice oblique statement referred to above was issued to you under section 73 of the Act for reasons stated therein. Since no payment has been made within 30 days of the issue of the notice by you, therefore, on the basis of the documents available with the department and information furnished by you, if any, demand is created for reasons. Well, this is also cyclostyle. This if any shows for reasons and other details attached in the annexure. Please note that interest, if any, has been levied up to the date of issue of the order. While making payment, interest for the intervening period between the date of order and date of payment shall also be worked out and paid along with the dues stated in the order. In case any refund, it's contradictory. Thereafter, Lordship kindly takes the next page. This is the gist of the order as they always do, my lord. Again, a tabular form, simple calculations done. And page 49 is the annexure, which is the actual order.
Of adjudicating authority.
Of the adjudicating authority. This is the actual order at page 49.
Date?
My lord, this is dated, signed on 4/10/2020. That's October 4, 2023. It will be visible at page 50, my lord, from the signing signature. এটা একে বল প্রিন্ট করতে, তুই যাস না ওকে পাঠিয়ে বল প্রিন্ট করতে। এটা কি মাই লর্ডের অর্ডারটা? আচ্ছা ঠিক আছে, ওটাই
Give me the number and date.
Yes, the order. This is my lord, this is not your lordship's order. This is Honorable Justice Joy Singh Gupta's order. I'm trying to find your lordship's order as well. একটু অফিসকে বলো।
একবার খোঁজো না। হ্যাঁ, নাম্বার তো পাবে কি করে? তুমি আমার নাম দিয়ে দেখো না, জিএসটি অর্ডার কি আছে। আগের বারে দেখো, জানুয়ারি মাসে আমি যখন এসেছিলাম।
Yes, my lord, I'm placing that order, page 49. The table below, the opening of the order, the table below shows the summary of discrepancies noticed during scrutiny of returns. The same language lordship sees. GSTR 3B furnished by you with reference to the information available, if any, in GSTR 1, 2A, 9 and 9C for the aforesaid period. The table has been quoted down. 2 paragraphs have been added in the next page. That is the only difference perhaps. You were directed to deposit the due tax as specified as above, along with the applicable interest and penalty, if any, and intimate the undersigned on or before the date specified in the corresponding DRC 01A. In case you intended to file any submission, clarification, reconciliation, or intend to appear for hearing either in person or through an authorized representative, the same might be done on or before the date specified in the corresponding DRC 01A. You had not responded to the notice, and therefore notice in GST DRC 01 under section 73(1).
This is the show cause notice. You have not responded.
Yes, And this is the order, my lord. Yes, you had not responded the notice, and therefore notice in GST DRC 01 under section 7311 of the CGST WBGST Act 2017, read with the section so and so IGST, was issued mentioning your liabilities, fixing the date of your reply by so and so, but again you have not submitted any reply against the SCN DRC 01. Hence the notice in DRC 07 now may be issued. DRC 07 is demand notice. Now may be issued as per provision of the said act, mentioning your liabilities, fixing the date. So it's like, if I may very humbly say, execution first, judgment later. There's no judgment. Finished, complete. The order is completed.
So now then you preferred appeal.
Then I preferred an appeal. Now, then I preferred a rectification. In the rectification, I got considerable amount of relief. But without going into that, my lord, because whatever I have not received in the first instance, lordship knows way better than me, because if something is not done at the very first instance, which is supposed to be done, howsoever more opportunities they gave me in the next or the later half does not suffice. So thereafter the rectification order came. I'm not entering into that rectification thing, my lord, because that is completely accounts based. And now thereafter, my lord, kindly comes to my appeal.
Your appeal from rectification?
From the rectification order.
Show me the rectification order.
Very well.
Dated.
My lord, the rectification order is dated. Yes, this is at page 59, my lord.
Dated?
My lord, this is dated 16/10/2023. October 16, 2023, my lord. Page 59 and 60. This is again another format, and the main order will be available at page 61. Signature is at page 63, yes. Because lordship will appreciate what has happened. At first, the demand was around 118 crore. From that, it scaled down to 20 crore. So lordship can very well understand the anomaly in the whole process. And my humble submission is even this will not remain. And then after the rectification order, my lord, at
rectification order, what was the original claim?
My lord, the
demand.
Original demand was GST DRC 07 থেকে দেখা যাবে. The original demand total was yes.
Original demand for rupees?
For rupees 11 crore. Naki daro 60. No, 1 crore 15 lakh. No, lordship, I tender my apology. This is 115 crore.
ওইটা কি ওই নীল দেখলাম নি, শোনো না, ওই নীল হিয়ারিং হয়নি এই ব্যাপারটা ছিল? শো দেম ওদের মেশিনে দেখা যাচ্ছে তো? ওদের মেশিনে দেওয়া যাবে না, ওই সামনের মেশিনে?
No, that was done because they were not given opportunity of being here. They were given opportunity for rectification.
No, they were not given opportunity. I have, in fact,
original demand was for rupees
115 crore 60 lakh.
Give me the figure. I can't.
115 comma 60 comma 12 comma 406.32.
Okay.
And thereafter, after rectification, it came down to
yes.
It came down to an addition needs to be made, which is confirmed at appeal. So I should refer to the appellate demand notice, because here the addition needs to be made. Yes, the total demand was Babare. My lord, it will be clear from page 83 of the petition.
What is that?
My lord, that is the demand notice, the final demand notice where the appellate order confirmed it. That was the same demand in the rectification as well.
Show me the appellate order.
Appellate order, yes. My lord, kindly comes to page 83 once because
That's the appellate order.
that's the appellate, the demand
Show me
notice
the
after
appellate order.
78, my lord. Page
Dated?
78. My lord, this is dated February 17, 2025.
Page
78, my lord. Only a small হ্যাঁ সেটা তো আমি জানি, কিন্তু ওখানে টোটালটা দেওয়া আছে কি? টোটালটা দেওয়া নেই তো, আবার যোগটা করতো। ও ইয়েস, দেওয়া আছে তো। এই যে এই পুরোটা টোটাল হবে।
আচ্ছা, next.
It's 65, yes.
78.
78. Here, my lord, the operating portion of the appellate order starts from page 80, last paragraph of page 80. Observations of the appellate authority. Everything has been diluted and they have, should I place, my lord, they have refuted. Only one thing has been accepted, that is my certain voluntary payments made before everything, which they had not calculated even in the rectification process. So that was directed to be credited.
Which part you agree?
Yes, my lord will kindly see at page 80 it starts, 80 at the bottom, observation of appellate authority. From here it starts, and the only portion where they have given me a credit is at 81. Excepting that, all wished away. May I place, my lord? My lord. Page 81, if lordship takes the last but one paragraph. In this regard, not the AO is also directed to give due credit to the payments made by the last but one paragraph, the last but one line. No, AO is also directed, the next para. AO is also directed to give due credit to the payments.
AO is who?
AO is the adjudicating officer. AO is also directed to give due credit to the payments made by the appellant through DRC 03 after due verification. That is the only line which has accepted a fragment of my contention. Because this they cannot say no, because this I have paid in the government exchequer. I have the challan staring at its face. They cannot say no. Otherwise, all the other things which were left open in the rectification order, the appellate authority did not touch. If I may place this before your lordship, may I place the whole, that 4-5 paragraphs?
Lordship,
I'm reading from page 80, last paragraph.
I got the order, Lordship, but I am no. 1821 of 2024, Lordship. 1821
1821 যেটা বের করেছো
of 2024. I am not the Lordship,
1 of
but
2024.
1821
1821 of
2024.
2024 order dated
Order date is 3rd September 2024. Here the Mamuna Rahman and Rima Sarkar appear, Lordship.
yes
Yes. The appellant in from page 80, last paragraph, my lord. After careful consideration of the grounds raised in the memo of appeal by the appellant, supporting documentary evidence is submitted. The proceedings and the order by the adjudicating officer and the provisions of so and so, this appellate authority has following deliberations to make. Then on the next page. The appellant in his ground of appeal has only disputed with the discrepancy deleted by the AO as tax short paid on the outward supply. It has been submitted by the appellant that during the year under current proceeding, some outward supplies under.
one second.
I know, I know.
This is with reference to Lordship personal hearing. The dash dash.
NA.
Dash.
Lordship.
All right. Yes.
Yes. So thereafter, as per serial number 1 of the description of discrepancies noticed, the tax short paid outward as mentioned hereunder. Now, my lord, again, the issue is he has gone back to the rectification order where also certain quanta are only showed. I do not know from where they are getting this. And thereafter, my lord, will see everything is on my hunch. I am applying, I'm answering, and whatever is within their gamut, they are accepting, and rest they are saying, no, this is not acceptable. The same, Lordship kindly skips some paragraph, and at the bottom, after the last table, appellant in his petition has explained that the demand as cess was accepted in full and paid through DRC 03 along with partial interest involved therein, but has disputed the demand of cess in APL 01. On the other hand, appellant has demanded examination of point 10 of GSTR 1, which shows the total IGST at nil, rupees so and so, each as CGST and SGST, and rupees so and so as cess. A statement of GSTR 1 B2B additions and B2CS amendment is also filed by the appellant, which shows total CGST and SGST of different months amounting to this and this, which said to be corresponding to B2C sales amended to B2B sales. But the total output tax as per GSTR 3B is so and so and so and so. As per GSTR 9, each under so and so. But the appellant has failed to properly explain how the amended liabilities were reflected in 3B in presence of such disagreeing liabilities. Well, pausing here for a moment. These are hyper technical things coming for the first time in appeal, without giving me an opportunity of producing all my documents. And moreover, there is a perfect provision under the GST laws which says an appellate authority cannot adjudicate. He cannot get into the mode of an adjudicating authority. Precisely here, what the appellate authority has tried to do is to cover up for the adjudicating authority, my lord. Because these questions should have been given in the show cause notice itself. And voluminous documents I had produced. Many of them were relevant, many of them were irrelevant because I do not know the answers. I do not know the questions. So my only humble submission is this is.
Is there any statutory form for show cause notice?
There is a statutory form where the reasons is kept blank. What they generally do as appended in a fresh sheet. That is what they write, and they issue a very speaking show cause notice. Here, Lordship, seen the show cause notice which they have appended. It is only a table. And, my lord, under the GST regime, there cannot be any other offense other than short payment of tax, excess claim of ITC, interest. There cannot be anything else. But why short payment arises due to GSTR 3B2B mismatch? My supplier not filing for returns, my supplier not paying the government, my supplier being non-existent. I could not show the movement of goods. There are thousands of reasons. If they do not tell me what are the allegations against me, I ask this question to myself, how will I satiate their query? So my humble submission is, let the matter travel back to the adjudicating authority. Whatever relief I have got in rectification, let that not be touched. But the rest of the demands, as far as the rest of the demands are concerned, let it travel back to the adjudicating authority. I will be appearing there personally. Let them give me a time for appearance. I will appear there, produce all my books of accounts, because they have never given me an opportunity of being heard. And these complicated matters, my lord, here personal hearing with documentation is needed. That is the be all and end all of my submission, my lord, more or less.
Yes. My lord, the so called notice might not be not given a personal get. They also been given that wouldn't have to be any. But you are given an opportunity with different restrictions. They would have said that, give me a chance for hearing. During the appeal also, they could have said that, give me a chance for hearing. They have never mentioned that in the petition. After that, in the order of the appellate authority, could have then challenged the appellate authority order as well as the so called. I cannot make my case better than this is so called.
No, hearing was given at the stage of rectification.
No, that is my application. That is my application. Applicant is also my application, or not application, a memorandum. It's a representation, my representation. In my representation, I have to be heard. But regarding their proceeding, which they have initiated, they had to give me the opportunity of being heard. And
very well.
And even if
now,
they
even if today they are sent back before the adjudicating authority, then also what will your department produce before them so that they can give answer to your query and specific points to be raised by you?
Yes. Show cause notice. There is no factual.
No, I'm not on that. I'm not on that. If they have to go back before the adjudicating authority, then what they are saying? They are saying the show cause is incomplete. But one problem, if they give you a fresh show cause, in the meantime, let's say 4 issues were there.
Yes.
3 has already been decided in your favor.
Yes.
Which are not going to be reopened?
No. According to the appellate order, whatever has been transpiring from the appellate order, the department has a few questions on that appellate order. Let those questions be answered by me before the adjudicating authority. Only one point is remaining open right now.
Where that question proposed by the appellate authority?
Yes. This table, my lordship sees, page 81 again. As per serial number 1, this table. Description of discrepancies noticed. The tax short paid on outward supply has been mentioned as under. Liability on outward supply declared in GSTR 1 and liability of outward supply declared in GSTR 3B. So their main moot contention is GSTR 1, I showed less, GSTR 3B, I showed more. That is what they should have told me. Nothing more. I only need to satisfy them on this point, why this discrepancy arose. Lordship sees it is 2,23,32,803 in GSTR 1 and in GSTR 2 it is 2,20,000. Computation. This is not the gross.
So if this paragraph is with the table quoted,
my lord,
as per serial number 1,
yes,
and then the entire table, the
yes,
2-column table.
2-column table, Yes.
It's quoted.
Yes.
And it is directed that the adjudicating authority shall decide on this.
This issue. That will solve the problem, because this is what we wanted to know, which came out at the fag end of appellate order. And now, Milord, I do not have a tribunal to go as well to nudge this issue.
Why?
There is no tribunal. It has not yet been formed.
That's why writ petition.
That's why writ petition. Otherwise, I wouldn't have troubled your lordship, because this is a very hyper-technical issue, which needs to be appreciated by the help of my books of accounts, my records, my challans, and everything.
Yes, fact-finding inquiry.
Yes. That is not at all what the writ court is.
Yes, Mr. Counsel, what do you say?
Except the last AO is also.
Yes. Yes, yes, yes.
Except the last slide.
Because that they have already given me. Yes.
Where?
AO is also directed to give that what I read for my lord.
Due credit to
Accepting that line, yes.
This cannot be sent back to them.
Race means which portion?
Total portion, from the appellant is gone.
As per the appellant.
Yes, my lord. From the appellant to the.
This is the decision.
Yes,
This
my
is
lord.
the decision of the.
Yes, this is just saying that the adjudicating authority has to.
The question raised is from as per serial number 1.
Yes, my lord.
That's right.
Yes,
And
yes.
the 2-column table.
Yes.
Yes.
Correct?
Yes, my lord.
Then they say, but on examination of the order of AO means
AO means the adjudicating officer.
adjudicating authority.
Yes.
Tax shortfall on these heads were rectified on application of the appellant and was determined only as follows, with interest and applicable penalty. So the determination of the AO is in the second table. Now, this second table determination you are accepting.
No. This is the question and the determination at second table.
Okay.
And thereafter the explanation.
Thereafter
The explanation why he thinks this to be that.
Why the AO thinks.
Why the AO thinks and why the appellate authority is also accepting it. These two paragraphs are the explanation. The first table is the question. The second table is the answer to that question as per the department.
And the next paragraph.
This paragraph is the explanation to that answer.
In support of that answer.
In support of that.
So that answer has to be set aside. Answer has to be set aside. And this part has to be relegated before the adjudicating authority. Yes. আসুন আস্তে আস্তে খুব আস্তে আস্তে
If my lord wants, I can give this judgment as well, if lordship wants.
What is that?
Honorable Justice Joy Sengupta's judgment.
So have you got mine? দেখি এটা কি এটা নাকি ওইটা আলাদা দেখো দেখি একটু Is this the one? Same one?
So the petition is no. This is way broader, my lord. This is way broader. Lordship kindly peruses this one if lordship so wants. This is also a reported judgment, my lord. I'll give the reporting as well. That one. Ha, nishchay. May I place the relevant portion? May I? Page 2, third line, but no date was mentioned for personal hearing. which was essentially required by the petitioner to explain the show cause. The appellate order also does not properly appreciate the question of having a proper. That's a different issue altogether. Learned counsel for the state denies allegation and submits that pre-show cause notice was in fact uploaded in the portal in time. The appellate order is also reason one. Fresh show cause notice is directed to be given. Necessary time extended. Learned counsel whether pre-show cause notice was issued and uploaded in portal does not provide a. It appears that the case is about non-payment of tax due or short payment of it refunded erroneously or input tax erroneously availed for. Therefore, it was necessary for the authorities to grant an opportunity to the petitioner to have a personal hearing where books of accounts could be produced and the issues explained.
No, but you have been granted hearing. Personal hearing was granted to you.
No.
At the rectification stage.
My lord, it was not granted. I made an application.
That's all right, but you were hard.
Yes, yes.
You were hard.
Yes, that was not expired.
This judgment will not apply.
Very well. Very. I
should. যেটু ফর্মে করুন তো সব অ্যাপিয়ারেন্স গুলো লিখে দেবেন তারপর through this writ petition the petitioner has challenged the impugned order passed by the adjudicating authority dated
yes, my lord, just one moment.
Dated 4th October 23. Page of what?
October 4, 2023. Short list of dates will speak for itself.
Where is it? October 4, 2023.
2023, yes.
Passed by the adjudicating authority, annexure
P3, my lord.
P3 at page 23 to the writ petition.
Index টা বার করো। My lord is asking P3 is at page 46 to 50.
At page 46 to the writ petition. And the order of the appellate authority dated February 17, 2025. Annexure
P10.
P10 at page
78 to 82.
78 to the writ petition. Paragraph. The relevant facts are only narrated. Paragraph. On the alleged ground of evasion of tax. Please,
Yes, I'm following.
Yes, both of you.
Yes, I'm following.
On the alleged ground of evasion of tax, a pre-show cause notice dated August 24, 2023 at annexure P1 at page 33 to the writ petition was served upon the petitioner. Under the said pre-show cause notice, the total demand was for a sum of 1,10,60,265.58. Look at your notice. Yes. On several counts. পড়ুন সংখ্যাটা পড়ুন পড়ুন 10 বলিনি 1,10 110 কোটি ঠিক আছে 1,10,95, 0.58 several counts mentioned there. The petitioner has not replied to the show cause notice.
This is pre-show cause, my lord.
Did not reply to the said pre-show cause notice. Then show cause notice page 42. What is 35? Is 35?
My lord, page 35 is the order, explanation, the actual show cause notice. That should have been the reasons for the show cause. That's the reasons.
At 42.
That's the pre-show cause notice, the reasons for that pre-show cause notice, which is supposed to have those queries, which it does not have. Annexure to the pre-show cause notice.
Annexure to the said pre-show cause notice at page 35 to the writ petition shows that the period of scrutiny was between April 2018 and March 2009. Various description of discrepancies has been mentioned therein.
May I? Headings, my lord.
But in a cryptic manner, only with the alleged quantum of evasion of tax. Then a show cause notice was issued dated August 31, 2023, Annexure P2 at page 42 to the writ petition. The total evasion alleged in the said show cause notice was rupees 1,18, 1,18, 60, 34, 164.25 on various counts mentioned therein. Annexure to the said show cause notice at page 42 to the writ petition shows
44.
44 to the writ petition shows diverse alleged description of discrepancies noticed by the authority. The same are also cryptic and only with the amount mentioned on account of alleged evasion of tax. The petitioner did not reply to the said show cause notice since the notice did not disclose the detail of the alleged descriptions of discrepancies. Following the said show cause, an adjudicating order was passed, an adjudication order passed by the adjudicating authority on October 4, 2023, Annexure P3 at page 46 to the writ petition.
Under section 73,
Under section 73 of the
relevant GST acts, CGST and IGST, SGST both.
under the relevant CGST and
WBGST Act.
WBGST Act. Bracket A for short, the relevant act. Relevant act. The said order of the adjudicating authority has fixed the liability on evasion of tax to the extent of rupees 1, 1,15, 60, 12, 406.32. পড়ুন।
To the extent of rupees 1, 1,15, 60, 12, 406.
First.
Rectification
The petitioner applied for rectification of the said order of the adjudicating authority, right?
Yes.
Please listen.
Yes,
please
I'm
listen.
completely at simple.
On October 16, 2023, the order was rectified and the rectification order was passed
Total code. 340, 349, 8.
by the adjudicating authority. Annexure P6 at page 59 to the writ petition. After carrying out the rectification, sir, if you do not hear me.
My lord, I'm hearing your lordship because I'm calculating the total amount which came after rectification. Lordship
It's mentioned 6.9956.
No, it's a total addition of that. That is why I was adding, my lord. I'm completely at.
কি বললাম?
Carrying out the rectification.
কি বললাম?
Petitioner applied for rectification of the said order of the adjudicating authority. On October 16, 2023, the order was rectified and the rectification order was passed by the six at base.
After carrying out the rectification, the demand was fixed at a total sum of rupees
40,37, 877.
877. Pardon. Being agreed by the said order under rectification, dated October 16, 2023, the petitioner preferred the statutory appeal under section 107 of the relevant act before the jurisdictional appellate authority. First. Here you have been heard.
Here also has been. And here the rectification order remained unchanged. Excepting the
After
fact,
hearing the petitioner, after granting an opportunity of hearing to the petitioner, the opportunity of hearing to the petitioner, the appellate authority has passed the impugned order dated
February 17, 2025.
February 17, 2025. Annexure P10 at page 78 to the writ petition. When the appellate authority did not interfere with the finding of the order of the adjudicating authority on rectification.
Save and accept, my lord, that payments that I had made under GSTDRC 03 was taken into was told to be taken into consideration. The last line of the appellate order, last but one line of the appellate order. Page 81.
The appellate authority directed the adjudicating authority to give due credit to the payments already made by the petitioner through bold all cap DRC-03 after due verifications.
This is the only thing that they did in appeal, otherwise it remained constant.
First. Acha, you show me this table, the impugned table from the adjudicating authority order on rectification.
My lord, that will not be there. In all probability, that will not be there because they have calculated it in a monthly and periodical way. Cess is calculated in excess of that. So what they have come to, that 40,37,000 and odd, that will be the same thing on this table that is in issue. Because this is the only point which the appellate authority has stated to be found to be demanded. And that will be again
Mr. Boudayan Chakraborty, Bhattacharya, Learned Counsel, appearing for the petitioner. Submits that the instant writ petition has been filed to a limited extent, challenging the finding of the appellate authority and the adjudicating authority being upheld by the appellate authority. Only to the extent
that is the demand that is reflecting in the demand notice, GST Appeal 04.
To the quantum of demand
Finalized in appeal.
Confirmed in appeal.
Page 83 and 84. That's the demand notice after appeal.
Appearing from the demand notice
in GST Appeal 04.
Dated February 17, 2025, issued pursuant to the direction of the appellate authority. comma, annexure P11 at page 83 to the writ petition. Paragraph. Learned counsel for the petitioner submits that the adjudication made by the appellate authority, though after granting him an opportunity of hearing to the petitioner, upholding the finding of the adjudicating authority, which was not granted. Now, upholding the finding of the adjudicating authority,
modified in rectification.
After rectification, but since the show cause notice being the source whereupon the rectification ultimately took place has not disclosed the adequate materials on the basis of which charges of evasion of tax was levied against the petitioner at the adjudicating stage, comma, the order of the adjudicating authority on rectification confirming the said demand for a sum of rupees.
Total, so there is. I'm giving the total from that demand notice. Add code. Determined 622, 182, 33, 53, 476, 62, 219. বলো কত হলো? Yes, the same. It tallies, my lord. 40, 37, 877.
877. কি বললাম? পড়ুন। পড়ুন।
Made by the appellate authority after granting of holding finding of the after execution but so called being the court where execution argument took place close deal from the basis of which charges of operation of tax for every digital at the stage comma the order of the application on execution confirming the statement for application for 3, that 7
was in clear violation of the basic principle of natural justice. Principle of natural justice. Hence, the demand notice following the order of the adjudicating authority and the appellate authority should be set aside. Including the portion of the order of the adjudicating authority on the basis whereof the said impugned demand notice has been issued. Paragraph. Yes. Mr. Pritam Das, learned advocate, led by Mr. Mominur Rahman, learned advocate, appearing for the state GST authority, submits that the rectification order was passed after granting an opportunity of hearing to the petitioner. And then the order in appeal was also passed after granting an opportunity of hearing to the petitioner. The learned state counsel submits the opportunity of hearing was granted and the principle of natural justice was complied with. Next.
And the appellate findings are, I object to their, why is the appellate pending is wrong? I say that the appellate pending is correct.
He further submits that they further submit that the finding of the appellate authority is just and lawful, right? Just and lawful.
It's just a law. No, it's a law.
And therefore the demand notice should not be interfered with. Paragraph. After considering the rival contentions of the parties and on perusal of the materials on record, this court, at the outset, reiterates the settled legal principle. Paragraph. When an act of an authority would have a civil and evil consequences, compliance of the principle of natural justice is inevitable and mandatory in law. If on the record it appears that an opportunity of that compliance of natural justice has not been followed at the first stage where it is mandatorily is required to be followed, such defect cannot be cured. 86 Supreme Court. Such defect cannot be cured at any of the subsequent stages.
Also 1958 Supreme Court.
86 is there. Subsequent stages, even at the appeal stage, at the stage of appeal, which is the continuation of the original proceeding. That's the language of the Supreme Court. 86 Supreme Court.
General medical supply, whatever. That is 86 Supreme Court.
কি বললাম? কি বললাম?
When an act of an operating would have
compliance of the principle of natural justice.
And basically, on the record.
Full stop at Paul, if on the record.
On the record, compliance of at the first stage.
At the first stage, oblique instance. Where it is mandatorily required to be followed,
such cannot go at any of subsequent stages, even at the stage of appeal, the consideration of the
by granting, by complying the principle of natural justice. Post. Paragraph. After considering the show cause notice in the instant case, and on perusal of the order of the adjudicating authority on rectification, this court is of the firm view that on the basis of the materials on which on the কি বললাম? Materials on which the evasion was evasion of tax was alleged against the petitioners. Was alleged against the petitioners, comma, petitioner, comma, such materials were never made available before the petitioner to deal with it. Such an action, such an act is clearly in violation of the basic principle of natural justice. And has rendered the finding of the adjudicating authority to the extent it was upheld by the appellate authority and the demand notice was issued for a sum of rupees 40,37 ওই quantumটা বসিয়ে দেবেন is bad in law and not sustainable in law. Full stop. Accordingly, the order of the decision the order of the adjudicating authority on rectification dated October 16, 2023, insofar as, sir, please. কি বললাম? It has confirmed the demand for a sum of rupees such and such stands set aside and quashed. Set aside, bold, quashed, bold. Full stop. Consequently, the portion of the order of the appellate authority dated February 17, 2025, to the extent it has upheld the above finding of the adjudicating authority also stands set aside and quashed. Full stop. Resultantly, the impugned demand notice dated. Show me.
81 minutes, 80 page.
Demand notice dated
Same. The date of order is the notice
February
of
17, 2025, Annexure P11 at page 83 to the writ petition also stands set aside and quashed. Paragraph. In view of the above, to a limited extent, this court is of the firm view that the issue should be sent back for a fresh adjudication before the adjudicating authority only to the following extent, as quoted from the appellate order. Colon. এইখান থেকে কোট করে দিন। Kindly come to page 81.
My lord,
Mr. State Counsel, kindly come to page 81. If I simply quote from as per serial number 1.
My lord, that only the last line, the last line that is confirmed, the rest is set for the adjudicating authority.
That is the explanation.
No. Kindly listen to me. As per serial number 1 you have got,
Yes, my lord.
then the table, just to that extent, if I send.
Then the demand would not be for the amount of 40 or some odd lakhs. The total demand is 40 some odd lakhs. That is a confirmed.
No. If I send for reconsideration by quoting this portion, as per serial number 1 of the description of discrepancies noticed, the tax short paid onward supply has been mentioned as under, up to the table, then the first table. That's all.
No, my lord, the second table has to be included because that second table is.
So
what
up
they
to the second table?
Yes,
Yes, sir.
Up to the
Both
second
the
table.
both the table.
That's right, up to the second table.
Yes.
ঠিক আছে। কি বললাম?
Because first table is the.
কি বললাম? Only to the following extent quoted from the appellate order, impugned appellate order. করুন কোট, খুব সাবধানে করুন। বুঝুন। কমলা রং যেটা দিয়েছি ওই টেবিল করে একদম ধরে ধরে, ঠিক আছে? লিখুন। The entire exercise to consider afresh to the extent as indicated above shall be completed by the respondent number 1. After granting an opportunity of hearing to the petitioner with a sufficient advance notice of hearing, and then by passing a reasoned order in accordance with law, positively within a period of 4 weeks from the date of.
I will not have any problem, but 4 weeks might be a bit difficult for them.
Then within a period of 8 weeks from the date of communication of this order.
My lord, I'm grateful.
Full stop, paragraph.
But since affidavits are not.
Paragraph. It is made clear that this court has not expressed any opinion on the merit of the claim raised by the Revenue Department and the defense taken by the petitioner. Full stop. All points are kept open for adjudication before the adjudicating authority. Who shall proceed independently in accordance with law. Paragraph. Since affidavits are not called for, the allegations made in this writ petition are deemed not to have been admitted by the respondents. Paragraph. With the above observations and directions, this writ petition bold WPA 1783 of 2025 stands disposed of, without any order as to cost.
Grateful.
Lordship, for the respondent number 4 and 6, the CGST, Lordship.
Yes, Mr. Dilip Kumar
Agarwal.
Agarwal, learned advocate, Matharopur, appears for respondent number
4 and 6, Lordship.
4 and 6.
With Viswaraj Agarwal, Lordship.
With Mr. Biswaraj Agarwal and an advocate. আর ওই ও প্রীতম করেছে স্টেট, ঠিক আছে, আর উনি পিটিশনার।
Lordship, deeply obliged.
Referring General Medical Council versus Pacman, 43 appeal case. That is what was quoted in 86 AIR.
But 86 Supreme
Yes,
Court
yes,
itself
86 Supreme
is
Court
there.
quoted.
I learnt it.
Grateful.
From an eminent member of the bar who is no more there, was a doyen of the bar when I was working with him in a matter. It's 6 Supreme Court.
Well, it is an enriching experience for us also as well.
No, it is a, thank you.
Grateful.
Deeply
That's the
obliged.
fundamental principle. That once the violation is there for compliance of natural justice, it's always a violation. It cannot be cured. Even at the subsequent stage, you give an opportunity of it.
Pre-decisional hearing cannot be substituted with post-decisional hearing as well.
That is diluted to a limit, great extent nowadays. Nowadays that is diluted unless specifically mentioned in the statute. All right.
Grateful.
Well, grateful, Lordship.
I apologize for appearing with this.
No, it's all right. Chalo. কাজ হয়েছে, হয়ে গেছে। Next.
This matter
Matter will be taken up tomorrow. First order for the day. Compassionate. Who is on the other side?
Dinhata municipality. May not be because Lordship.
Has it been rejected?
No, I have made a.
What is the date of the death?
Date of death is Lordship, 3rd April 2024.
When application made?
I usually appeal for Tirhata municipality.
Appear.
But my regular.
When application made?
Application was made, Lordship, within 2 months, but the representation was given here, it has been received by the Dinhata municipality without any date. Then Dinhata municipality has forwarded.
No manufactured document.
No. Then
Policy is there for appointment?
Yes.
Policy is
Dinhata
there.
municipality has sent it to the Director of Local Bodies, West Bengal, to do the needful and for the.
Give him a copy, he will take instruction and come back.
But the municipality cannot grant compensation of appointment. It has to come from the local body. But that now it has made this.
Take instruction and come back tomorrow. Take instruction on phone. Give him a copy.
Yes.
Give him
Copy that. This scan.
here and now.
I have to make a scan.
Service ko
Delivered. Let's scan.
Give him a copy. Tomorrow. You take instruction. Take the serial number.
Yes, madam.
The petition number and take instruction from your client.
But day after tomorrow, madam.
Monday.
Oh, sir. Monday.
Come tomorrow, let's see.
Right. Get from.
Snatch it.
Yes, my lord, I know it. Other matters I have with you. Yes.
Getting out of control.
Absolutely.
Well, the 54 minute, it can be taken up in the next circuit.
Next one is 54.
54.
You're sure that this is a very bad court for the matter?
So the bad matter, not that bad, but a bad bench definitely.
Bad matter was bench.
No, bad bench definitely. Your lordship has expressed an adverse opinion, my lord, so. And not that urgent also.
পালিয়ে যাচ্ছে। On the prayer of Mr. Bikomaditya Ghosh, Learned Counsel, appearing for the petitioner, the writ petition shall appear in the available circuit bench in the month of December 2025, subject to its convenience. Paragraph. M.S. Rima Sarkar, Learned Counsel, appears for the state with Mr. Pritam Das, Learned Advocate. Next.
Lordship,
I'm for the statement.
Lordship, Mr. Mishra is appearing. Lordship, this is a case of GST registration. Lordship, we have made the necessary correction.
Yes, sir.
देखिए ना, give it to him. Yesterday's judgment.
Yes, I know the judgment. Can I just go through the correction and come back after 5
You,
minutes?
you here and now, do it. Take your time. Take your time. You have filed appeal. You take your time.
No, Lordship.
You could not. Time expired.
Expired.
You appeared in yesterday.
Yes, madam.
Okay. Names, appearance.
Yes, but that also done.
Yes,
Yes, ma'am.
Here I have also decided one additional point, the point you have raised. Entertainability of the writ petition. It was not there before the division bench or the coordinate bench.
Yes.
That question you have raised, I said, yes, I can. I've given my reasons.
The revenue of the state will also be generated in property.
Not only that, that is one aspect that is already decided by the division bench. The point I have decided that your rejection is purely on technical ground. Substantive right to carry out business cannot be suffered.
Get production.
I'm for the petition.
Lordship, in this matter, there was a direction to field inspection, Lordship.
One indulgence I am seeking. Prior to go to the merit of the case, I have to draw your Lordship's order. It is 20th January 2025. Kindly see.
Has he filed report?
No, till now.
Till now.
Even, my lord, can you see the last order?
The August, Lordship, inspection has been done, Lordship. Report has been yet to be.
Yet?
Yes, Lordship,
Come with
fine.
the report tomorrow.
Lordship, Monday, Lordship.
They are sick for the last.
Monday, Lordship. I led
Come
by,
report tomorrow.
in this matter, I led by Mr. Hirok Barman, Lordship. Is
Doesn't matter. Come with the report tomorrow. Whoever leads you. Passed over for the day.
Lordship. Grateful, your lord.
Come with your report tomorrow. Get the report ready. Come tomorrow. क्या बात की लिखी है? ও আচ্ছা আচ্ছা না এটা দেব Excuse me, where is Mr.
Vikas.
No. Pritam Das. Ask him, come. And where is the learned advocate? Learned advocate. Then last one. No, not yours. 55. Bring the learned advocate, the lady. এই কাগজটা দিই। Where is she? Send for her. Send for her. Yes, madam. এটা কোনটা?
This was item number 36, yesterday's list. I have.
I'm not on that. Not on that. Wait. এটা কি এটার? Kindly take your correction, annexure P2 at page 24.
Yes, Lordship.
Show me.
Lordship,
আস্তে।
Lordship, below order for cancellation of registration, this whole statement is written over here. Like I have written handwritten.
That's right. Wait. Find it from page 24 where it is and what are the grounds.
Oh.
Page 24 of the writ petition. What was the reason for cancellation? Here? Mr. Counsel, State Counsel, you take your brief.
Yes, ma'am.
ওই অর্ডারটার একটা কপি দাও তো বের করে। Give me that previous order. Number and date.
Focus on. The focus is not annexed and in this order, not very clear, the reason for this. Well, show code not an exponent. Show code. Show code that's good.
Do you find the same reasons of cancellation?
Lordship, then
Same reasons for cancellation?
then kindly keep this matter tomorrow.
Yes. In that matter, only the returns were not filed. Right? And in your case, you did not deposit the tax. So, two things are same.
No, Lordship, exactly.
Non-filing of return is a procedural defect. Otherwise, it was good. And you have defaulted.
Then Lordship, kindly keep
Who is leading you?
Mr. Jagriti Mishra.
Ask him to be there tomorrow.
Yes, Lordship.
Passed over for the day.
They are pleading their same paragraph that not for non-filing of returns on. That is pleaded in the petition.
Para 4.
Paragraph 4.
Keep these notes. Point it out at the time of hearing. Right? এটাকে এখানে গেঁথে রাখো, ফুটো করে। You bring your suggested order tomorrow also. Let's see. Who is on the other side? Key matter. What is the matter?
I am led by Mr. Jana. Matter relating to higher scale of pay.
So it calls for affidavit.
No, my lord, it is well settled by the division bench judgment.
My lord, 57, your lordship, my lord, the 5 minutes left, your lordship, take up tomorrow, my lord. My lord was pleased to direct on 28 January, 24 January 2025 to file a report why these two division bench judgment apply to my case. This is my lord was pleased to do.
Report filed.
Report has not yet been filed.
Lordship, there is a Mr. I am led by Lanet Hero Bormon in this matter, Lordship. There is a three benches judgment, Lordship, larger bench judgment. So we would like to rely in the last occasion. Also, we have relied this judgment, Lordship. Kindly fix the matter on Monday, Lordship. We'll come back with the judgment, Lordship. Already coordinated.
That two division bench judgment has been affirmed by the larger.
There is a larger bench judgment
but
also.
she is saying there is one larger bench, later
Yes,
larger
yes.
bench.
Larger bench, Utpal Kanti Karan affirmed that those two judgments, two division bench judgments.
Honorable Justice Harish Tandon, Kaushik Chanda, and Lordship.
My lord knows.
No
my
mention,
lord.
Lordship.
Utpal
So
Kanti
kindly
Karan.
fix the matter on Lordship
Larger
Monday, Lordship.
Tomorrow you
Lordship, actually due to his personal difficulties, Mr. Bormon will not be available tomorrow.
All right, you ask for accommodation tomorrow. If he is not there, I will grant you.
Lordship, grateful, Lordship.
Is it item number 58, my lord?
Yes.
58. In item number 58, I am appearing on behalf of the respondent number 5 and 7, my lord.
Yes.
I'm for the petitioner, Lordship. Lordship, on the last occasion, The respondents were directed to file report in the form of affidavit option.
They have filed.
Yes, actually, my lord, we had received the report, but it's not a complete, so I am unable to file the affidavit today.
Come tomorrow.
Maybe it fixed.
Come tomorrow. No.
My lord, Monday,
Yes, tomorrow. When it was directed?
next week.
When it was directed?
31st July.
If that from 31st of July, if you could not have filed till today, you will not be able to file within another 6 months. So come tomorrow. Come tomorrow, passing it over, bring the report.
No, Friday,
No. Come, yes, which means that tomorrow, come tomorrow, and then Friday I will take up your matter. No problem.
next month.
Friday
No,
will be
no.
a holiday.
Tomorrow. Bring the report tomorrow.
Grateful.
Now, we had received the report, but it is not complete, so I am unable to file the affidavit, your lordship.
It is not complete.
No, ma'am.
So which is not a report at all. So come tomorrow. Pay cost and take time. Only 10,000. Pay cost and take time. Yes.
Lordship, morning.
Come tomorrow. Yes.
Grateful.
Lordship, on the last occasion, there was the direction given to the respondent number. To the respondent number 2, 3 to file a affidavit in the form of a
Report in the form of.
report in the form of an affidavit. Lordship,
Yes,
the
who is
matter-
appearing?
Lordship, the matter relates with, there is a flat, I am the bona fide owner of the flat. And what happened, there was a attachment that was made by the ED within that building. As because the plot number and the Khatian number, that concerns me also. So when I went to proceed with the sale, continue with the sale proceedings, what happened that the ATSR, the concerned authority, the registering authority, they stopped my proceeding. Lordship. Whereas it has in the last occasion, they have already admitted that they do not have any objection if my property gets, if the sale proceeding continues and my property gets transferred. I am a aged man. I am a 71.
ED is a respondent.
ED is a respondent.
Which
Respondent
respondent?
number 3. Respondent number 3, your lordship.
Has he filed any affidavit?
No, lordship. No affidavit has yet been filed. And actually, my lord, I am selling this flat for my medical reasons. I need
That's
to
all
go through a
right.
surgery.
That's all right, but who appears for respondent number 3?
On the last occasion, Mr. Deepak Sharma appeared for the respondent number 3.
Where is he?
You have the respondent number 2, your lordship.
I have
Respondent number 3.
respondent number 3 appeared on the last occasion, but
Give him another notice. You just inform him.
Lordship,
Come to
I don't even have any communication. He's not from here, not from this bar association, or not from the Siliguri or the Jalpaiguri bar association. For what I will
Because
be able
this
to.
matter will be difficult without affidavit.
Yes, lordship, but I have already paid the requisite stamp duty, the registration fees. But what happened after that, when I presented my deed for the registration, my registration was stopped, which is very much evident from the P4 of my writ application, lordship. The difficulty here is Mr. Deepak Sharma, he is not a practitioner of this Calcutta bar.
Who normally appears for ED here? Because the additional solicitor, the deputy solicitor general, I find is there.
Yes.
Can he represent the ED also? Where is the deputy solicitor?
After station.
Very well, come tomorrow, let's see. Next.
Lordship, for item number 16, playing for fix the matter next week.
Next week? No.
Next week, Lordship, because What happened, Lordship, for the petitioner, Mr. Roy Mohashaya will be appearing in this matter and one of his family member is in hospitalized, Lordship. So due to that.
On the prayer of MS. On the prayer of MS.
Tanya Bhumik.
Tanya Bhumik, learned advocate appearing for the petitioner. Since the pleading counsel, Mr.
Roy Mohashaya, Bhaskarjit Roy Mohashaya.
Bhaskar
Jit
Rai
Roy.
Mohashaya. Bhaskar Rai Mohashaya. Learned pleading, কি বললাম, since the pleading counsel, Mr. Bhaskar Rai Mohashaya has not been attending the court due to a medical problem due to a medical issue in his family, the writ petition shall appear under the heading motion on September 11, 2025.
Malad, the last
paragraph. Respondents. Who appears for respondents? None appears for respondents. You appear for ED?
No, Milord, no.
Who appears for ED?
ED, Milord, the separate counsel, Milord.
Before Lordship rises, Lord, and small indulgence, Lordship, yesterday, Lordship had taken up item number 84 and 85. Very short matter, although it's in hearing, but my learned other side was also there.
Sir.
No,